And now will be the opportunity for the lawyers to make closing arguments. The state goes first.
We'll waive opening and just reserve for closing.
All right. Mr. Lumpkin?
Your Honor.
And if you want to move the podium around, you're free to do that.
Thank you. Is it on Madam Clerk? Sorry, I should ask you that before we put them in. It's okay. I'll be a bit. Thank you. Good afternoon, ladies and gentlemen. Again, as I've said before, we appreciate your involvement, commitment, absolute giving of your time and effort, your attention. Have done a very good job, as I've noticed, being very attentive to all that's happening here in the courtroom. There's a lot that's gone on that's been brought forth to you. There's been a lot of information. And trying to distill all that down in a brief few moments is hard to do. And that's why we're relying upon you to remember what you've heard. Okay? Y'all been taking notes. You've got good memories. You're going to talk to each other. You're going to finally get to talk to each other about this case. Up to this point, I'm sure y'all been, I don't know what you've been talking about. Maybe the Braves, maybe the weather, maybe who knows what. Maybe, Lord help us, let's have a good vacation this weekend. But you're about to have the opportunity to talk about the evidence in the case and start hearing from one another and kind of use your collective memories and your thought process to kind of come to a decision in this case. But I just want to say thank you on the front end for all that you've done already, what you're going to do. And I hope nothing I've done or said is anything that you would take and use against Eugene. He doesn't have control over what I do. And so I'm trying to do my best to just lay the cards out there. Let's let the evidence be seen. Let's question the evidence. Let's show what's not there. Let's make it very clear what we're dealing with as best we know how so that you can make a decision you've got to make. Because at the end of the day, I mean, it is your decision. Doesn't matter what I think. Doesn't matter what my colleagues think. Doesn't matter what the judge thinks. It's what you decide. Okay? And I also want to say, it's a tragic, tragic set of events. There's no doubt. No matter how you look at this case, the horrible loss that's happened to Beauty Couch's family is not lost on us at all. And I appreciate that. I hate that they have to go through a process like this. I hate that anything like everything ever happened to Beauty Couch. And it was horrific, and it was horrible, and it was terrible, and it continues to be a pain to Miss Thurman, and I recognize that. And I know she's in a position that none of us can be in. And I hate that for her. But given all that, I need us to try to move out of that difficult circumstance that we've seen of her and deal with the circumstance before us, which is, what does this case say about Eugene Louis-Jacques? Okay? No matter how horrible it is, and we don't deny, we know it was horrible. The question is, has the state proven beyond a reasonable doubt that this young man seated over here is the one that you need to condemn for this murder? That's what they're asking you to do. I'm asking you to do what I'm confident you're going to do on your end, which is take everything you've got and make the best decision with what you've got. At the end of the day, there'll probably be still more questions. And that responsibility does not lie with us. That lies with them. Now, there's a few things we can all agree on. Not only the difficulty of this death, but the difficulty of this moment. Okay? There's a burden that's about to be passed upon you to take this case and make a very difficult decision. Either way you go is difficult. Okay? It has implications either way. But what you're required to do, what the judge is going to tell you your job is and your duty is to listen to all this, take all this in, remove any sympathy for either side, and make a decision as objectively as possible. And that's hard. Listen, no one's going to kid ourselves. This is an emotional matter, and it's going to take an extraordinary effort on your part to overcome the emotion and make an objective decision. Now, I'm confident that you can do that. I'm optimistic that you will do that. I know the tendency is that we shrink from that responsibility as humans. It's hard to take that extreme step of making a decision in a jury trial, especially one of this nature and of this level of emotion. So I recognize that. We trust you with it. I'm going to be asking a lot from you to take all that you've heard and make a decision that may not make everybody happy. But it doesn't matter. It's not your job to make anybody happy. It's your job to decide based on what we've been provided. What are we supposed to do with that? What can you live with? What can you go home with and deal with tomorrow, the next day, next week, next month, next year? And we're going to talk a little bit about how that may play itself out. Now, the overall theme, if you will, the overall principle, I guess I should say, that we need to deal with here is proof beyond a reasonable doubt. You can hear a lot about that today, okay? You know basics about it. You probably know enough to really understand the basic concept, but there are some nuances that we're going to talk to you about. The judge is going to instruct you as to what that is, and I want to try to hit on some of those and highlight those for you a little bit, okay? I think ultimately the best part of the jury instruction that seems to hit home with yours, I believe, is it talks about a reasonable doubt as a doubt of a fair-minded, impartial juror honestly seeking the truth. You've indicated to us that you were impartial. We believe you're honest. And it's that seeking the truth part that's a little bit questionable. Not that you're not going to try to seek the truth, but that the state's going to ask you to try to seek for something that they can't provide you. They've given you pieces, and they're going to want to ask you to take some conclusions that they're going to say are reasonable and logical. And they might be reasonable, and they might be logical, but they might not be correct. And in fact, they're not going to have enough information for you to try to join this chain of reasonable doubt to overcome that burden. There's a lot of ways we'll look at that as we go through this, but I want you to understand that's what you're required to do. And what the judge is going to tell you too is, if after hearing all the evidence and weighing it, if you are unsettled, unsatisfied, or wavering in your mind, then that is a doubt that is reasonable doubt. If there's a doubt in your mind of any sort for which you can give a reason, and there's going to be several we're going to offer to you, but if there's one doubt in your mind for which you can give a reason, then that is reasonable doubt. And it would be your duty to acquit this defendant and find him not guilty. Okay? Our forefathers were very wise people in many ways. They were humans. They had their frailties, there's no doubt. But when they put together our constitutional framework, it's amazing how well it's worked for we're coming up on 250 years in our country. And it's amazing we've gotten this far, but it's because of the wisdom of those foundations and your opportunity to be a part of that gets us to where we are today. Thomas Jefferson said this famously one time. I like to quote it because it reminds me of my job here before you, and I hope it helps you think about your job. It says, "I consider trial by jury as the only anchor ever yet imagined by man by which a government can be held to the principles of its constitution." Now that's some 1700s flowery language, right? But he's saying the jury trial, the trial jury that you are the only anchor we have to hold the government to its burden, to maintain its principles of the very framework that we enjoy and live under. So that's why this is a big job. This is a big duty on your part. You're it. No matter what you've heard in the past, no matter what you've seen in other cases, watched on TV, heard and read in the paper, whatever it might be, you have the chance today to be one person to make the system work. And that's what we're going to ask you to do. We're asking you to hold the government to its own principles. Anchor in. Be solid. And when you do that, I believe at the end of the day, you'll find that in fact, there's more than one reason to have reasonable doubt, more than one cause for reasonable doubt. And the other thing that they gave us, our forefathers did, is due process, which is, of course, the requirement of reasonable doubt that we have. And that doubt can come, as the judge will tell you, from the evidence you've received. There's a pile of it. But also in the lack of evidence. What is not here? What should be here? What do you have an expectation to have, really in any sort of case of this nature, but certainly in a case of this gravity? What's missing? And why is that? That's what I want to talk to you about. As we look at your job, and we asked some of these questions when I was asking you, your panels before you began yours. We talked about the horribleness of a wrongful conviction. Some of y'all have studied that. Some of y'all have done some work. Some of y'all have done some interaction with some organizations that deal with that. And that's what this case sets up tremendously for. There's a great opportunity for a wrongful conviction in this case because the emotions are high. There's a lot of evidence. There's a lot of indication. There's a lot of direction the state's given you. And there's a lot of consistency among it. As I told you from the beginning, you're going to hear it, and you've heard it a lot. There's a lot of things about this evidence that are consistent with my client being guilty here. But that's not proof beyond a reasonable doubt. Okay? That's just giving you an option. That's a theory, a hypothesis that they're giving to you. But all this evidence is circumstantial evidence. Nothing wrong with circumstantial evidence. It can be very powerful. It can be very good if you actually get enough of it. But what the judge would tell you is when you're trying to, as the state is, seeking a verdict of guilt based upon circumstantial evidence, you cannot simply find that their theory makes sense, but you have to exclude every other reasonable theory. Exclude it. There's no other reason that this could have happened other than what they're telling you. And that's simply not the case here. Now, as we look at wrongful convictions happening, we're aware the history of our country has not been good. We've had many people wrongfully convicted for various reasons over the years. Most notably, of course, you know, is the racial prejudice that we've had over the years, gender prejudice that we've had over the years, financial prejudice we've had over the years, even governmental prejudice that we've had over the years. And the thing about prejudice is sometimes it can be very blatant and obvious. And thankfully, we've moved a long way from where we were 250 years ago. But we still got problems. We still got issues. And some of those prejudices are very subtle. In fact, they're the sort of thing that we don't even recognize that we have. If you ask me, well, do you have any prejudice toward this? Oh, absolutely not. But when we start acting and thinking, there's some subconscious pressures that we have just because it's how we've grown up. It's what we're used to. It's what we've seen. It's what's been accepted. And so the best way I know to ask you is to be on guard for that. Be alert that there's going to be some of those pressures, you might think of them, but some of them are prejudices. And again, that emotion is a big part of it, right? When we get upset and we get in our emotions about things, that can prejudice our thinking into swaying to, well, I want to be helpful here. I want to make this person feel better, and absolutely, we'd love to. But our job is not to make people feel better with our decision today, it's to satisfy you. That your mind is settled, satisfied, and unwavering. If you're going to hold the government to the principles of our Constitution, understand the duty that's been mentioned before, and I suspect the state will talk about it again. It is their duty to bring evidence to prove guilt beyond reasonable doubt. It is the duty they've accepted. It is the duty they're required to bring. But when we look at that duty, then the question becomes, well, what are you supposed to do with it? Right? Don't let anyone suggest to you or prejudice you into thinking you've got a duty to convict my client. You've sworn an oath to listen, to weigh the evidence, to take the facts and the law the judge is going to give you and apply them together. But the duty the judge is going to tell you that you have is if there's any reason whatsoever that rises to the level of reasonable doubt, it is your duty to acquit. It doesn't mean that you like it. It doesn't even mean that you say, well, I can just say, absolutely, I know he didn't do it. The only duty you have is to make sure if there's anything below that reasonable doubt, it is your duty to acquit. Now, if you find enough evidence in this case, you think, well, there are some missing things. There are certainly some things they should have had. There's certainly some things that got done wrong. But at the end of the day, I'm going to find I don't have reasonable doubt. Even then, the judge is not going to tell you you have a duty to convict. You are authorized to convict. But again, our forefathers were just very smart in understanding having 12 people, normal, ordinary, everyday people who don't know anything about a case can come in, had to sit through the agony of all of this. But we trust that they can make that determination and say, you know what? Even though I got the authority to do it, I'm not going to do it because I'm still just not satisfied. There's just something there that can't be answered. I want you to remember that. As you look at, looking at that duty, I want you to think about this. What evidence do we have? And I hope, as we've gone through this, I hope the end result of this, and you don't have to tell me anything when we're done, but I hope you walk away saying, you know what? I saw that defense attorney just take the evidence that they have and try to point out things that are in their evidence are missing from it. He wasn't trying to pull the wool over our eyes. He wasn't trying to fool us. He's just simply trying to get us to look critically at the evidence, okay? That's what I want you to do. So the first, most obvious thing, and I've hit on it a lot, and I hope I don't seem duplicative or repeating things too much. I'm really trying not to do that. I don't want to waste your time. But I do want to give you some things that you can go back and think about and hang your hat on, so to speak, as you think through this process. And again, the biggest thing is this was a terribly bloody event. Dr. Ashcraft mentioned that yesterday. We don't know how much of the 5 liters of blood that typically would be in Beauty Couch's body, but a large amount of it exited because she bled to death due to sharp force injuries, and that's horrible. But what we do know, as she indicated, that the nature of these wounds and the object that had to be used, that the person who did that had to have been in very close proximity to her. And in so doing, there was blood all over, and we would anticipate it being on that person. And wherever that crime scene is, well, another question about where this actually happened. At the end of the day, we don't know for sure. Certainly surmising, well, it must have been in that car, and that's why the car got burnt. That would make sense, right? We don't know that, but even if that's the case, we know that small red Dodge Dart that you got pictures of, there's not a lot of room to move there. And for someone to have caused these vicious 81 stabbings of Miss Beauty Couch, that there's evidence on that person. Absolutely. Has to be. And the evidence would be the blood with the DNA of Beauty Couch on it. And the thing about blood, it's a liquid, and it has a way of getting in things and sticking to things and being found. And thank goodness that's why we've got great investigators, right, to track down this information. And we swab and we get everything we can so we can bring it to you. But in this case, despite the horrific nature of this, not a single drop of Beauty Couch's DNA on Mr. Eugene Louis-Jacques, not in his car that they're suggesting he drove away from this scene, not in his residence where they're suggesting he went to after it was over. Nowhere. There's something you can have a reason to doubt. Someone who did this and not have a single drop of that blood anywhere on them, on any of their stuff? Reasonable doubt number one. Now, one would also think someone who's taken a pocket knife or some sort of knife like that, as Dr. Ashcraft opined, the type of injury, it wasn't a pair of scissors, okay? At least we're all in agreement on that. To the extent we got a pair of scissors in the car, as far as we know, at least from our expert tells us no, that's not indicative or consistent even with a pair of scissors. So the pair of scissors in the car that's burned, nor the pair of scissors that's found in amongst the stuff in Eugene's car. No one's suggesting that that's the murder weapon, okay? What we're told is some sort of small knife, pocket knife. It didn't have to be all that large necessarily because the wounds weren't that deep. Now, we don't know exactly how big the weapon was, of course. What we know is we don't have one. We don't have a single sharp object with Beauty Couch's DNA on it in this case. Someone who had to use the force necessary to stab into, and I hate to say it, but we have to talk about it, the wounds to Beauty Couch, to her head, her skull, her scalp, her neck, her back, her stomach. That took some force. And the repeatedness of it, and blood is everywhere, not uncommon, not illogical to recognize there's a good chance that person is going to hurt themselves and injure themselves with that knife. But when we see Eugene, there's not a single wound on him. Nothing consistent with him having stabbed someone 81 times. Certainly none of their evidence on him. Not even any indication that we would think we would find on someone who has forcefully pushed their hand into a knife over and over and over. Frankly, just the number of times it would wear you out. And as you get tired, that's why people tend to get cut, right? I hate even making an allusion to the OJ case. This is not the OJ case. I'm not suggesting that. But you had that bloody glove and you had that cut on his hand. Why? Because the brutality of that murder led to him leaving that piece of evidence on him. But we don't have not a single injury to Eugene. And that's why we brought that out over and over again. Because to the extent we do have, the one bit of blood we have is on a pair of shoes. That's Eugene's blood. But we know it doesn't have anything to do with this case. Because there's nothing from which he was bleeding on that day. And the detective was right. Well, we don't have any idea how old it is. Who knows when it got there? We collected it because we wanted you to have it. We wanted you to see it, so we'll have it all here. Thankful they did. Because it shows us all the more that Eugene didn't cut him. Well, we know he didn't cut himself because there's no injuries on him. And that blood on his shoe has nothing to do with this case. Now, the next obvious thing is the gasoline. There's no doubt but gasoline was found on the scene. I don't think there's any doubt in your mind that that's why this car burned the way it did. Interesting when you look at a case like this, inevitably there's going to be some mistakes made. Granted. But what I hope you have seen, and we saw it at its height just within the past hour or two, you get garbage in, you get garbage out. If you get bad information in, you're going to get bad information out. And if you want to select a story to give to somebody, well, you select the information you're going to give so that it only fits that one theory. And that's what's happened in this case. Now, the arson investigator, I have no doubt that he's done his job to the best of his ability, notwithstanding walking around through crime scenes with gas in the dirt with nothing to cover his shoes and walking through that dirt and then taking that same dirt and scooping it up and seeing if there's gas in it. Now, at the end of the day, it may not matter, okay? But it's just one of those things. If you're going to investigate a serious case, let's be honest about it, right? And so this issue, and maybe it's not even an issue to you, maybe it's clear to you as it was to me. Let's see if we can get this. It's been a while since I've used it almost, so here we go. Getting it there. All right. So the burn marks on the car. And I asked the investigator, he said, I made the opinion that it started in the back seat, passenger area, and burned that way forward. Seems obvious. Matches the reason we got red paint on the front, because the flames didn't get there, but the whole trunk is all but incinerated. Makes sense, but he made this opinion, but here's how we know that, because of the two colors on the door. And that shows us the burn pattern. And I asked him, because I thought it was obvious, and I wanted to give him the opportunity as an out. I showed him this picture. Well, don't you think that's just the shadow of the shed? Because it just happens to match beautifully with the shadow on the ground? No, it's not it. The burn pattern. Well, apparently, States 242 was taken a little bit later in the day because the burn pattern's moved. Well, of course we know. The burn pattern didn't move. It's a shadow. And while that's a simple issue, why do we have people wearing badges on this stand telling you something that's so obvious from the facts is not true? Because they're so focused, we want to give you this story. We want you to believe our version of events. We don't want you to question anything. We're the government. We know what we're doing. We take taxpayer money and go do our job. And this is a small example, but it's a great example of not being able to see what's right in front of you. The medical examiner yesterday, when did you do the autopsy? Well, they did it on August 23rd at 10 something in the morning. Well, we know the fire didn't even happen until afternoon that day. An obvious mistake. So did I try to pull the wool over anybody? I asked her again, what time was that? When did you do it? August 23rd. Well, the state knew that was wrong. So they come back and ask her. Now, let's be sure, when was it? Still, August 23rd. Okay, well, let me let you look at something to change your answer. Oh, yeah, August 24th. Again, does that matter in the whole scheme of things? Obviously, she did the autopsy after they got the body out of the car. But it's a symptom of the problem. We've got people who are just so focused on, I've got to get on that stand and say it a certain way because we want to get a conviction in this case. I can't explain it. It happens a lot. You saw it happen here multiple times in this courtroom. Let's look at the citation. This is, as I told you at the beginning, a little bizarre. Page 152, the citation found right there at the scene. And it's just so amazingly outside the log, away from the fire. so that if someone would be walking up on this scene, they would see it laying out there, which is what we saw happen. How in the world did that get there? Well, the state certainly, I suspect, will argue the person who lit that fire got that citation and either burned the top of it or ripped it off and burned part of it, and for some reason just dropped it, just left it there. Now, it doesn't have Eugene's name on it, but it's got a tag number on it. And for someone who's trying to cover up their tracks in hopes of diverting law enforcement so they don't look and see them involved, well, maybe we leave a little piece of evidence there that we can follow and track, and it worked. And it's reasonable for the police to follow up and see what that is. But we got on the phone, we got on our computer, we started tracking down this information. But no one really talked about what was right there in front of them. The citation is sitting there, innocuously, providentially, if you will, maybe, just left there. Notwithstanding the fact that if someone just started a fire with gas, with a piece of paper, they would somehow reach back and hold on to some of it. What does common sense tell us? Now, without knowing who the person is, we don't know how they specifically did it. But you light a fire with gas and it blows back on you, you let that thing go. There's no reason to hold on to it unless you want to leave it there so someone will find it so that they'll be thrown onto another track. And so we see it there, laid in the pine straw, nice and neatly. Close-up picture under a branch. The suggestion I think is going to be made to you, well, just after burning this, the paper just got dropped and just kind of wafted over there. A piece of paper didn't waft over there underneath the branch. It got put there. And somebody wanted it to be found for a specific reason. And that branch is put right there on top of it so it doesn't blow away. If someone's standing at the feet of Ms. Couch, as the fire investigator told us, well, that's where it started, and lit a piece of paper and then somehow dropped it and it just wafted around and landed over there, it would have had to waft around and then back up under this branch. I suggest to you that defies logic. That defies physics. But we were so caught up in looking at the citation itself, we didn't think about, well, let's just see how it might have got here. Now, to their credit, we tried to get fingerprints off of it. Certainly not Eugene's prints on it. None, what was the word? Not identifiable or not, I forget exactly what, you'll remember the word, not usable. What does that mean? You got some of some sort? Where are they? Why don't we see them? Let us see for ourselves how unusable that print was. Or maybe there's nothing. All we know is what they brought to us. But ladies and gentlemen, I think that's something for you to doubt. That piece of paper got there intentionally by someone. And to suggest it's the gentleman who then fled 3 states away, said, I didn't want to get caught. Not because he's done a killing, but because he knows he's a suspect of his girlfriend's death. But this horrible piece of evidence in some ways may be one of the best pieces of evidence for us, for you to see that didn't just happen. That didn't just fall there. First question, well, how in the world would it get there to start with? Well, we know Beauty and Eugene rode in each other's cars all the time. It doesn't take any moment at all for being in someone else's car, needing a piece of paper and getting that and having it. Maybe writing a message on the top of that sheet of paper, ripping it off, leaving that message wherever you're going to do it. And we know there's more top to it because the state put it in evidence. State's 152A, and you've got the whole piece of paper here. City of Fort Lauderdale letter with that same citation attached. We know that's where it came from, but where's the top? To suggest someone, well, I'm going to light a fire, but I want a smaller piece of paper to do that with some gas on it. That doesn't make any sense. No, not at all. I want that piece of paper. I want that part of it because I'm going to leave a trail for them to follow. I can't explain it. I can't prove it. But I can show you what the evidence is. And I want you to use your common sense and reason and say, that didn't just happen that way. It's intentional for a reason. Now, you've got the piece of earnings statement in Eugene's car. And yeah, that's odd. No doubt. Yeah, I commend the investigator. Well, I don't know if it has anything to do with this case whatsoever. Wouldn't make any sense for it to have started a fire with part of the piece of paper, but then just only burned a corner of it, leaving all the name information on it. It may have something to do with the other stuff that's in the car. I don't know. But we collected it because, it's a burned piece of paper. Makes sense. Good job. But it doesn't give us any indication. There's certainly no evidence of any gasoline on it. No one even bothered to try to get fingerprints off of it. See where it may have come from. But that's what you've got. So to the extent the state suggests you, well, this is the first nail in the coffin, well, it's one of the reasonable doubts you should have in this case. How about a reason for this? Now, the state's going to tell you multiple times, and they're right. And I think the judge will even tell you. Legally, you're not required to prove a motive. But there was a motive behind this. Someone stabbed 81 times. There was a motive. What do we know about Eugene and Beauty? They're in a normal, respectful relationship. Everything's fine. They're going well. Mom knows him. Gets along well with him. In fact, she goes and stays time at his residence sometimes. No problem whatsoever. In fact, that's who she calls when she's trying to find Beauty. Because there's no evidence of any problem at all. No indication of any problem. The only problem we've got is from a friend of hers, Miss Kendrick, who don't like the fact that he hangs out where they work. Now, you saw her body language, how she responded when I tried to ask her what I thought were simple questions. Why is she... Well, the emotions are high. I get it. I want to understand as much as I can what people are going through. But any jealousy shown in this case at all, that's where we saw it. Well, our relationship was good, but it seems like she's not as spontaneous as she used to be. Why is she so bothered by that? Why can't she just answer a simple question to me? Because those emotions have gotten to a point that maybe there's a jealousy there that she didn't like Eugene taking away her friend. And there's one way to get back at him for sure. I don't know that happened. I'm not saying that did happen. I can't prove it. All I can tell you is the only evidence of any animosity here is in that testimony. And it's not between Eugene and Beauty. And you'll see these Instagram posts that gave her concern. Someone just writing some information. Doesn't say anything about Eugene, doesn't reference Eugene. If the state tries to suggest and connect to you, well, this is obvious. Here's where that motive must have been. There must have been something bad going on here. Well, that's 3 links away from common sense. There's no connection there. They want you to draw one, but I'm asking you to be the anchor. Hold the government to its principles. We're not going to buy a theory without any evidence. We talked a little bit about the gas. You know, great work was done in this case to get all these videos of everything they could find a white Nissan doing. I don't know if you're like me in the past few days and just driving around town, and every time you see a white Nissan now, or frankly any sort of white car that's of that same shape, it could be a Mercedes, could be a Honda, it could be a Toyota Camry. It's white. It's got tinted windows. It's got a sunroof. Maybe like my Hyundai Genesis got a little reflective thing on the side of the car. I'm glad I wasn't driving through Austell back in 2023. I might be on one of those videos myself. And believe me, I'm not trying to make light. It was honest work. And Detective Smith did a lot of work to get that together. But how about one piece of information that Eugene Louis-Jacques bought some gas? Apparently he's driving around all the time. Got to have some gas at some point. We got him at a gas station one time, and he doesn't even open the pump. It appears he might be throwing some trash away. We'll talk about that in a minute. But sticking on the gas, premeditation is not required, but somebody had to premeditate this burning. You don't just show up. Well, most people don't just show up with gas in their hands or in their cars to throw on a scene. Somebody had to go get it. Had to be some sort of container to put it in. There's a video of it somewhere. But the closest place we can think to look, we find, I think there's several places. The only place that has been provided to us is that racetrack, a few miles from Eugene's house. Not a single drop of gas. Well, could they have expanded their search a little bit? Yeah, they could have. Did they? No. I'm just looking for this time frame. Why? Because this is the time frame that's going to show us what we want. And even again, if it's not intentional, maybe there's a subtle prejudice. Law enforcement officers done this his whole life. He's so geared toward, I want to contribute. And he is contributing. I'm not suggesting he's not. But he's contributing the piece that they want. A limited view. But at the end of the day, there's nothing at all indicating or showing that Eugene ever bought a drop of gas that was used in this fire. How about videos of where he lives? Why don't we have something from there? Well, you were told, I looked at it, and there was, I forget the phrase, you'll remember it, no video of evidentiary quality or something of that nature. Sound like a good law enforcement phrase. Yeah, I decided you don't need to see it. Well, what might it show us? He bothered to show us a ghostly figure of some car in the dark that he wants to convince you he can identify as this same car, even though he can't see that it's white, can't see that it's got tinted windows, can't see a sunroof, can't see any molding. But he's so convinced you need to see that because it looks suspicious in this church parking lot. Well, how about just a video that shows this car coming back to the residence? Maybe we'll see Eugene get out of that car, and then we'll see what he's wearing. What does that tell us? Maybe there's some indication of some blood, someone who's been in a horrible killing. Maybe there'll be some haste. Maybe there'll be something to indicate he doesn't even want to be seen. I'm going to ask you, well, did you even go to the apartment? And at first he couldn't remember that he did. Again, I wasn't trying to fool him. I wasn't trying to trick him. We know he went and got the guest information, trying to get to that, and he can remember that. But for this purpose, why don't we just have a single picture where that residence is? Now, we see the door and going in, But where is it in relation to a camera? Maybe we should see that bad quality video. We might not think it's that bad. We might think it shows us some reasonable doubt. Because there's nothing to indicate that he came in at a time looking like he had just stabbed somebody 81 times. Maybe there's some video of him coming out of the apartment. I don't doubt if they'd had him coming out of the apartment with a bag of McDonald's food. We'd have a video of it. But for some reason, they don't want us to see whatever that video is. All you can take from it is there's absolutely no evidence of Eugene going in or out of that apartment with anything to do with this murder. That's what we got. The racetrack. Odd, sure. Put trash in one trash can, then move it to the other one. Was the first trash can full? I don't know, we can't really see it very well, whatever's between the pumps. It goes on to the other, but what stands out, I hope to you, certainly stands out to me, this is broad daylight, 11 o'clock hour in Marietta, Georgia, at a very full, busy racetrack gas station. If he were throwing away some clothes or a murder weapon or evidence in this case, does it make any sense that's when it would be happening? Or would it not be in the dark of night? In some way that nobody would see it. No one would be able to have any chance of observing it. Or maybe it was just what it appeared to be, is throwing away some food bags from the car. And whatever trash was in the back, throwing it out into the air vacuum area. Maybe it was planning to vacuum and decided it didn't need it. All we know is it didn't make a lick of sense to suggest, well, that must be why it's all missing, because it all got thrown away. Now, we don't have any of it. We didn't even go there to see if maybe there's some traces of blood around the trash can. Metal trash can. Might have some blood there. And if it's got one drop of her DNA, we'd have it. We don't even have a picture of it. We got a video that's obscured by the perspective of the camera. But why don't you just give us a picture? Let you make a decision of your own to decide if the government is being held to its principles. Yeah, Eugene driving all around Austell, the car going around Austell at least. We know he tried to contact Beauty on that fateful day, and then she wasn't responding. It's unusual that he might be trying to see where she is, what's going on. I can't guess as to what was happening. All I know is we don't have a single video of Eugene ever getting out of that car in or around that residence on any of those occasions. Not a single time. And it suggests, well, he was in the process of stalking her down, I guess, to kill her, or to going to burn her body. Why do we not have a single frame of evidence that shows that? Well, as far as you know, it did not happen. The only thing to suggest otherwise is a theory that you can choose to take a logical leap if you want to. I'm asking you, I'm begging you, please don't do that. This is your one chance. This is your opportunity as a juror to hold the government to its burden. The swabs. Again, good police work. Over and over and over and over. 2, 4, 6, 8, 10, 12, 14, 16. Over 20 swabs. Trying to see, do we have any blood? No, 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 no. You're going to see the reports. Now, at first we thought, maybe we've got some. We've got this glowing mixture in the bathroom. State went through a lot of troubles to bring you those pictures so you would see them and maybe have that guttural reaction. Oh, there's a CSI moment. There's the glowing proof. But when we test it, we find out, well, no, Wasn't blood at all after all. 3 of those 20+ swabs showed some indication of blood, but not Beauty Couch and not even Eugene Louis-Jacques. Because we took his swabs, we got her blood at autopsy, we know it's neither one of them. Now, it is an extended stay motel in Smyrna, where he's only been staying there for a few days. You saw the discoloration. I mean, it's so faint, it appears as though somebody's tried to clean that up over time. But there was enough there to glow on the one spot that it turns out, on the lip of the tub, a very small area. And then on the side of the tub, one of those was, and one was not. They swabbed it twice, and thank goodness they did. So it shows, well, there might be something there, but it's certainly not what you see in this glowing picture. I don't even know why they showed it to you. They can answer that. I'll suggest to you, it causes an emotional response. It hits on those prejudices that we know, hey, we're used to watching exciting stuff like this on TV. If we see that, we're going to think something of it. But at the end of the day, the proof is not there. There's no evidence that that's anything to do with this case. How about some things we just didn't do at all? How about a tool mark examination? We paid good people at the crime lab to do some work. As it turned out, we were happy to stipulate to their results because it helps paint the full picture of what's not here. But we know, well, yeah, we got people there who could look at this and maybe give us an idea what the weapon was. That might help us look for it. Maybe we'll find some evidence that Eugene had that weapon at some point. Well, no, we didn't even bother to try. We just don't do that. It's available, but we didn't feel it necessary. Okay? How about text messages? How do young people communicate in our world today? I'm amazed, maybe even appalled sometimes when I see records that show text messages in the hundreds, thousands. My fat thumbs, I can't text that much without making an error and having trouble with it. Right? That's not me. But they had an opportunity, to the extent they want to suggest, here's where the last conversation was had. Here's the last call. That must be when it happened. Well, if we had those text messages, we might see a full conversation that happened for hours. Might have gotten some information about how nice the conversation was. They did it in time. Detective, can you do that? Well, yeah. Is that a special thing to do? Well, you just kind of have to mark it on the subpoena. I didn't subpoena that. Why? And frankly, this time it doesn't even matter why. Are you satisfied with that? Does that settle your mind? Does that cause you to waver? We're not satisfied with that. You're asking us to condemn this person for murder? And you can't simply check the box that says include text messages? But the one that I know has got to be on your mind, I hope. We went through the trouble of, on that scene, of bagging the hands of Miss Beauty Couch. And you'll see those photos, those autopsy photos. They're horrible. But when you see the hands, you'll see some very long fingernails. And the reason why we bagged those, didn't do it years ago, well, we've learned when there's an attack like this, especially if it involves two people in a relationship in close proximity and it's violent, there's usually some attempt to fight them off. And there might be some DNA. In fact, that's why we do it, to get DNA in those fingernails. Now, not a single injury, not a single scratch mark on Eugene. We already know that. Was that why they didn't try to get those scrapings? Well, gosh, let's not even look at that, because he's already got that covered because he didn't have any injuries. The DNA of the killer could be sitting right there, could have been sitting right there in those fingernails. And the medical examiner just chose not to do it. ladies and gentlemen, it's unthinkable in some ways, except for the fact we're human. But the state's going to ask you to be superhuman and see through all that and come up with your own conclusions. I'm begging with you. Be an anchor. Hold them to their principles. Hold them to their duty they've accepted. And then think about this. Many of y'all, we talk about forensic shows and whatnot. Most of you have seen them at some point. I just can't imagine somewhere down the road that some testing of that being done or some other case coming along with a bunch of stab wounds, someone in the area, the fingernail scrapings are done in that case, and we find out who that person was. And we'll go back and look through all the technology we have and find, guess what? They were in Austell on August 22nd. Maybe they have a motive that we don't know about because no one looked at anybody else. Maybe it's one of these social media followers. Maybe there's something to do with one of those people. It's an emotional world. We heard about that. You may be seeing it now. I don't know who they are because no one looked. But they want you to have that burden. Somewhere down the road, as you're sitting there and watching a case, cold case file, I know, wow, that's the case I was a juror on. And I was led by the state to convict Mr. Jacques of murder. Knowing good well, they didn't have the most obvious piece of evidence to have made it clear, to exclude him or include him. If you're satisfied with that, jump on the train. Do what the state wants. Follow their theory. They're going to give you a lot of visuals that suggest to you, well, this is all just weird. It must be because he's the one who did it. And it's consistent. I've got to admit, it's consistent. But if you're only looking for one thing and you pick and choose what you want, you can find consistency with that. And then today, we get a special agent of the FBI. Wow, that must mean something. What prejudice is that talking to? Well, he's top notch. And listen, I don't doubt he's a very smart guy. Obviously, he is. There's way more than I do. I don't even know that I've got all of what he was saying, but I get enough. And I think you get enough. And you saw it happen right here this morning when questioned, when there's a little healthy skepticism. Well, let's look at what you're actually showing us. Even in your own information, that body is not at the distance where someone would have had to have been, well, if it had been Eugene, where we know he was, somewhere in that arc, even the closest spot, that's not where the body was. Now, Miss Green tried to convince him otherwise. No, that's not really right. It's really out there somewhere else. Oh, okay, sure. So you're telling us you don't stand by what you... No, I stand by what I said. Yeah. And I know sometimes it seems petty, and again, I'm not a brilliant person. I'm small-minded, but I like to think simply. I know if you take that map and zoom it in, you're going to be able to see way more clearly exactly what space we're talking about. Maybe had he done that, he would have recognized at least what the state thinks is, had it in the wrong spot. I know when I check for my son on 360, sometimes I think he's all the way to Gainesville. Well, he's not quite that far. When I zoom in, all of a sudden, where he is on a big map, looks like he's way up here. Well, then it shrinks in and I see exactly where he is. That's what we have here. And we know we have it here because the state tried to do it with their own little map. They zoomed in as best they could get this little machine to work and try to convince them, well, here's really where the body was. Right? This is where, right? You're wrong, right? Do you have that capability at FBI? Can you get a zoomed in map? Absolutely you can. Why don't they? Because they want you to just say, well, it's the FBI. We trust them. They're the government. They got all sorts of gadgets. And they're smart people. But are you satisfied with what they brought to you? They brought a visual to you to pull on your emotion. Wow, that's just powerful. And it is powerful. but is it accurate? Garbage in, garbage out. Garbage in, garbage out. Theory in, consistency out. And I'll be honest with you, that I try not to get upset about a lot of things in trial as I've aged. You would not have wanted to see me 20, 30 years ago as a prosecutor, as a defense attorney. I'm not perfect. But when I see someone try to manipulate something right in front of your eyes and try to tell you that's not what you're seeing, I really did it right another way. I'm not going to show you what it is. I'm not going to bring a map to you. I'm not going to make it clear. In this most horrific, important of cases, we got a guy. Let's just condemn him for murder. Got no motive. Got no physical evidence. Got no reason to think anything other than he's in a good relationship and is trying to find out why Beauty is not responding. Yeah. Was it foolish to take off and go to Louisiana? Of course it was. But some segments of our society know, if something's happened to my girlfriend and I know I had contact with her just the night before, and I am who I am, I'm going to be the suspect. And when people start calling and voicemailing or texting him, trying to see what he might know, is it foolish to take off? Absolutely. Is it foolish to use a fake name? Absolutely. He said why. I didn't want to get caught. And the state's going to say, well, there's a confession. He didn't want to get caught. He must mean for murdering somebody. Are any of his actions even consistent with a murderer? In Louisiana, blue lights come on behind your car. And if you've just committed a murder in another state and you haven't done anything otherwise wrong, he didn't have his turn signal on, apparently. What does that tell a killer? I need to get out of here. I need to go. Did he do that? No. He stopped immediately. He complied with every command. He got, what? Did I do something wrong? That's what he's trying to find out. Ladies and gentlemen, be very careful. The state's going to have a chance to speak, and I won't have a chance to come speak afterwards. And it's going to be compelling. Like I said, I don't have a PowerPoint to show you, but I hope I'm making powerfully some points to you about what you have to deal with. You're going to hear the judge say them again, and I'm trying to give you those sticky points so they'll stick in your mind. Because at the end of the day, it's your burden. The state's done a great job of putting together a case that fits their theory that gets the person they want to get. And listen, is there a prejudice there even for the state? Yeah, we've got a victim mom who gave her life to this young lady, and we want her to feel better about it. I get it. I want her to feel better about it. But not at the cost of a wrongful conviction. Not at the cost of an incomplete investigation. Not at the cost of absolute evidence that was disregarded that would give us an answer. Don't be satisfied with that. Don't be settled with that. At least be wavering to the point that you say, it's going to be tough to write not guilty on that verdict form. Because I don't know that he's not guilty in general sense. And I suggest to you, there's a lot of things you may be thinking. Levels of possible guilt that make you feel better. But they're all below the burden of beyond reasonable doubt. Now, I can't prove Eugene's not guilty. I don't think. I can show you a lot of things that certainly go toward that, but I can't prove who did it so that you know it's not him. You might be thinking, well, it's highly unlikely that he did this. It's less than likely, and maybe probably not. And that's on the very low end. You may not be there. You might say, well, it's not unlikely. But it could be possible that he's not guilty. Well, possibly not guilty doesn't mean I didn't know anything before I got here on Monday, and now I'm thinking it's possible that he's not guilty. Well, that doesn't make him guilty beyond reasonable doubt. Well, he may not be guilty. Or, you know, perhaps he is guilty. Maybe that's where you find yourself. Perhaps he is. But that's below proof beyond a reasonable doubt. I suspect he's guilty. He's the best suspect we've got. He's the only suspect we've got because of how the state chose to not investigate this case. Well, he's possibly guilty. You know what? He's probably guilty. We're still not there. If you're thinking that, that's where you come down on this. If that's the best I can get, he's probably guilty. The right thing to write on that verdict form is not guilty. Legally. And this is a legal process. It's not making any moral judgment. This is just in this process, in our constitutional framework, I'm an anchor. I'm one person. I've got an opportunity to do the right thing. Probably guilty. It's likely he's guilty. It's highly likely he's guilty, may be where you find yourself. But that's not proof beyond reasonable doubt. Because you can think it's highly likely he's guilty, but still wonder, why is there no DNA? Why is there no gas? Why is there no blood anywhere connected to this crime? Why is there no motive? Why is there no video of him even being out of the car? Why are we looking at maps that should be zoomed in to tell us exactly where someone was? They're going to suggest to you, here's proof that he had to be there where that body was. And you've seen visually that's not what their evidence is. They may try to suggest to you, well, we just kind of had that wrong. And maybe there's some other time we just didn't map out. I want to be real clear when I ask about these maps. Starts August 22nd at 7:50 a.m. Well, what happened to 5:45? The time that they suggest to you, this ghostly picture is the car at the church, that somehow we don't ever see come or go, even though we see other cars go by, their headlights on. Well, he must have had his headlights off. Well, that's not what the evidence shows us. That must be when it happened. Well, why don't we have a daggone map? Why don't we use our FBI guy who's got all the resources that are possible, in this case, that we could need, to map that out. Show it to us. Give us some proof of that. And then August 23rd, we know the fire, it's right afternoon, 12:18, we get the call. August 23rd, between 9:50 and 12:07, they did give us. And it's a big map. And the one thing, and I asked him this specifically, and I hope you wrote it down, I'm going to remind you, the one camera one at 9:50 and 24 seconds, the closest he was ever in this area in that time frame when this fire had to have started. It didn't light gas, and it took 4 hours to go up in flames. Some 2+ hours before, the closest he was somewhere east of Austell. And we don't even know exactly how far that is because they didn't give us a big enough map to show us where's that camera one. Why don't they do that? Why are we missing it? What's right in front of our eyes? The rest of the day till 12:07, he's nowhere near there. Does he come back later after the fire? Well, there's some indication of that. But he can't have burned it after the fact. He's not there. Their own evidence shows us he's not there when it happened. All right. I want to leave it with you. And I can't be in that jury room with you. Lord knows you don't want me in that jury room with you. You don't want the state with you. You want to be able to look at this yourself. You want to be able to be the one, be the anchor, be someone who cares for the Constitution, who cares for the framework we live under. If you're going to be celebrating a little over a month, 250 years as a country, we've got problems still for sure. But I hope you can celebrate that despite our problems, we've got the best system available. But it's only the best system because people like you are willing to give of your time and effort. I know it's probably been a horrible inconvenience to all of y'all this week. Thank you so much for giving that. But don't give up yet. Don't see this, well, I just gotta get to the next step and be done because Memorial Day is on Monday and I gotta celebrate. Listen, you can resolve this very quickly. You can take time and look through all these 600 whatever pieces of evidence they've got. Well, they have 600 pieces of evidence. Well, so they can say, well, we've shown you everything we've got, but we know that's not true. We know there's things that they haven't shown us, or there's things that they just chose not to create a visual for, or they chose not to get. Ladies and gentlemen, this is a difficult position to be in for sure. I'm trying to do the best I can to use my knowledge and experience to let you see what's really going on here as best I can. I'm limited by what they chose to do. I'm not trying to pull the wool over your eyes. I hope you see everything that we looked at are facts. And if I've got something wrong, then you're the judge of that. So you know what, Miss Lumpy, you were just wrong on that, okay? That's your job. You've got to live with it when you go home at the end of this decision and finally get to share with your family and friends. Here's kind of what we did. If you determine to convict Eugene of this, be ready to explain how we did that without a single drop of blood, a single drop of DNA, a single weapon, no motive, and the best piece of evidence were never even looked into. And Lord, help us that you don't have to watch on a show 5 years from now, the real killer has been connected to another case. I'm asking you to find Eugene not guilty of all of these charges for the very reasons that are set out before you. The process, the framework, be the anchor. Don't give way. Don't be swayed by what hits your emotions or your prejudice or, listen, we're from the government. You can trust us. We can trust them to a point, but now you've seen it yourself. What can we trust them to do to bring us evidence? How about a medical examiner who will just simply take those fingernails and get those scrapings and send it to the crime lab and be tested? There are so many specific reasons for you to be unsettled, unsatisfied, and wavering. That is reasonable doubt. That's what this case calls for. And upon your making that determination, I'm asking you to find Eugene not guilty of each and every one of these crimes. And come out with your heads up high. It's going to be emotional. Some people won't be happy. But you can't make other people happy, but they can go away knowing you've done your job. You've done what you need to do. And maybe the dissatisfaction will be where it should be is, well, why didn't y'all just do some simple things that were at your disposal? I'm asking, I'm pleading, I'm imploring you upon your duty as citizens, as Americans, as jurors. You vote your conscience based on the evidence or the lack of evidence. If there's something, any one of those things, or maybe multiple things that you have a reason to have doubt, dissatisfaction, write not guilty on that verdict form each and every time. And I appreciate your time. I appreciate your attention. I appreciate the effort you're going to put into this. It's about to be yours. You choose what you can do with it. Thank you.
All right, now it is the state's opportunity.
former Chief Justice Melton said, there is no justice without jurors. No truer words have ever been spoken. Our criminal justice system cannot work without each and every one of you. So we appreciate your time and attention the past few days. You all are truth seekers. That is the oath that you took at the beginning of this trial, to ascertain the truth. That is your job. Does anyone know what verdict means? Verdict is Latin for the word truth. It is about to be in your hands to apply the law that the judge gives you to the evidence that was presented in this case and return a true verdict, a verdict that speaks the truth. So I want to talk about the law first. The judge is going to give you the charge in this case, and you'll also have a paper copy of that. So don't worry about writing down every single word the judge says. You will have a paper copy of it to go over in the deliberation room. But I do want to go over some of the things that you will be charged on. First is the burden of proof. There's been a lot of discussion about the burden of proof. As we told you in opening, the burden is on the state, and it's always with the state. It never shifts to the defense. Okay, we proudly carry that burden. Our burden is not proof to mathematical certainty. Our burden is not proof beyond all doubt. Okay, our burden is proof beyond a reasonable doubt. So what does that mean? What is a reasonable doubt? You will hear the court instruct you that a reasonable doubt is the doubt of a fair-minded, impartial juror honestly seeking the truth of the matter asserted. A reasonable doubt is the doubt of a fair-minded, impartial juror honestly seeking the truth of the matter asserted. All right, it is not arbitrary and it is not speculative. It must be based on fact and reason. I'm going to repeat that. It is not arbitrary and it is not speculative. It must be based on fact and reason. All right, put differently, a reasonable doubt is a doubt for which a reason can be given, arising from a consideration of the evidence, a lack of evidence, or a conflict in the evidence. In other words, I doubt this defendant's guilt because fill in the blank. Okay? You don't have to go searching for a reasonable doubt. Right? Again, you are truth seekers. You are not doubt seekers. You are not speculative seekers. You are not arbitrary seekers. Okay? You are truth seekers. And looking at the evidence that was top of that dresser there when I put to bed the night prior. My husband probably had no idea that bottle was there because it was behind the light that's on top of that dresser. My husband has never woken up at 5:30 in the morning unless it's for a golf trip. So I know he's not awake trying to pull a prank on me of some sort that he's never done before. My other one at the time was in a crib, had never crawled out of the crib or been able to open a door or anything like that. We have some animals in the house, but there's no paw prints in there. There's no way they could have gotten to the top of the dresser to knock something off. So I know immediately, based on what I observe, beyond a reasonable doubt, that that one's responsible. All right? Now, one could argue, well, you should doubt that the 2-year-old did this because there's no video evidence. There is a baby monitor on top of the dresser. I don't have some sort of, not prescription, but subscription to be able to have saved video. It's only live streamed through the monitor when it's on, right? But one might say, well, you should doubt this because there's no video evidence. Well, if there were video evidence, that's proof beyond all doubt. If you saw it on video, the whole thing being committed, that's proof beyond all doubt. That is not our burden. All right, one might argue, well, there's no baby powder residue testing of the hands, or you didn't look under the fingernails to see if there's baby powder there. Does that change anything? Does that really make you doubt that the 2-year-old did this? There might be an argument that, well, you don't know why. You don't know why the 2-year-old did this. Well, for the parents, rarely do we know why a 2-year-old does what they do, right? That doesn't change the evidence. We don't know precisely how he got up there. Did he use a stick that he had in his room to knock it over? Did he climb on the chair in order to get the baby powder bottle? We don't know. Does that change the fact that we know he's responsible? No. One might also try to argue, well, you didn't look into anyone else other than your other child, your husband, the animals. The idea that someone broke into our house in the middle of the night and just did this and left, right? That is arbitrary. That's speculative. That's making things up where there's no evidence of that. That is unreasonable. That's unreasonable. So even though there are things missing in this scenario I've given you, I think you all can understand that there is still proof beyond a reasonable doubt that my 2-year-old committed these acts. I want to give you another example of reasonable doubt. This is a puzzle, a 1,000-piece puzzle, all right? A lot of pieces to the puzzle. My kids love puzzles. We do them all the time. And at the end, this is what we want to see, right? We want to have the whole beautiful picture, beautiful puzzle in front of us that has the mountain and the lake and the trees and the sky and everything surrounding, right? That's what we want. But if the question is, do you have proof beyond a reasonable doubt that this is a castle, right? And that's what you're trying to determine. You can be missing all those surrounding puzzle pieces and still know that that is a castle. You want the pretty picture. You want everything surrounding it. You want that lake and the trees and the mountains. It's way prettier that way. But if the question is this a castle? It's still very obvious. Now you can take it a step further and be missing further puzzle pieces here. But if you look at this image, is there anything you could possibly put in those missing boxes that would change this from being a castle? Is there anything you could fit in there that would all of a sudden change this being a castle? And that's what I want you all to think about as we go through the evidence in this case. Because again, if the question was, is there proof beyond a reasonable doubt that this here is a castle? I think all of you would agree, yes, there's absolutely proof beyond a reasonable doubt that's a castle, because no matter what I fill in those holes, it's still a castle. So the defense said in opening, this is the highest burden we can put on a case, and that is true. But understand, that is not proof beyond all doubt. Proof beyond a reasonable doubt is the highest standard in our justice system. So don't let that fool you or make you believe something it's not. Our burden is proof beyond a reasonable doubt, okay? There can be missing puzzle pieces. There can be unanswered questions. As long as there's proof beyond a reasonable doubt that every essential element of the crime charged has been proven and that this defendant's identity or the person responsible for having committed it is also proven beyond a reasonable doubt. Okay, so you can have missing puzzle pieces so long as there's proof beyond a reasonable doubt as to every essential element of the crime charged and this person's identity as having committed those crimes. All right, in opening, the defense said the case is fraught with questions. We all want to know why this happened. We do. All right, we all want to know, was this some sort of sneak attack? We all want to know, was Beauty transported in her car? We all want to know why this defendant went back 5 times afterwards. We all want to know why he set fire to her body in the car. We want those answers, and it's okay to want those answers. Okay, but those are not reasons to doubt the evidence in this case. Those are not reasons to doubt his guilt. Again, the state is required to prove every essential element of the crime charged beyond a reasonable doubt, as well as this defendant being responsible for having committed the crimes, not the why. All right, so evidence. Let's talk about evidence. Evidence can be given by witnesses or by physical evidence. Of course, you have both in this case. Evidence, by definition, is the means by which any fact or issue is either established or disproved. So evidence can come again in the form of testimony or as exhibits. There's also direct evidence and circumstantial evidence. And you'll be charged on this, okay? Direct evidence is that which may be directly seen or heard or otherwise directly sensed, such as by smell, taste, touch. Okay, I'm going to give you an example of this, and I know it's an uncomfortable example, but this is the evidence in the case. Okay, this is direct evidence. All right, you can see with your own eyes that Beauty was stabbed repeatedly. You can see that with your own eyes. That is an example of direct evidence of the crime itself having been committed. Okay, now circumstantial evidence is proof of a set of facts and circumstances by direct evidence from which you may infer other related or connected facts that are reasonable and justified in light of your experience. So what is an example of circumstantial evidence in this case? There's a lot of circumstantial evidence. We're going to be going through all of it. This is just one example.
I do all that. There's a reason. Tell me the truth.
Try to avoid
Getting caught for what?
I was trying to get out of that situation, making that wrong turn.
What are you trying to avoid getting caught for?
He knows he's got a warrant out of Georgia already.
No, he doesn't.
I didn't know I had a warrant. I was trying to avoid getting in trouble for making that illegal turn. He said I was making the legal turn as I was turning to the lane.
Why would you give a fake name to avoid getting out of a ticket?
I don't know, y'all maybe let me know.
Nah, that don't make no sense, man.
All right, and that doesn't make any sense. You're observed making an illegal turn. Giving a false name is not going to get you out of that, right? He gave a fake name to avoid getting caught. Now, he's not saying to avoid getting caught for murder, right? It's not direct evidence, it's circumstantial evidence, because when you hear this statement combined with all of the other facts and circumstances of this case, right, you can infer his guilt. Again, this is one tiny piece. There's a lot more circumstantial evidence that we're going to be going through in a little bit, okay? Now, the law also says that one is not better than the other, okay? One is not better than the other. You could have a complete case that's completely direct evidence and nothing else. You can have a case that's completely circumstantial evidence and nothing else. Or you can have both direct and circumstantial evidence. Okay, evidence is evidence. One is not better than the other. So, testimony. All right, testimony is that which comes from the witness stand, from witnesses who are placed under oath. All right, there is a rule called the single witness rule, and you'll be instructed on this. The testimony of a single witness, if believed, is sufficient to establish a fact. What's an example of that? Deanna Thurman. She says she leaves for work every day at 5:45. Right? That came from her and no one else. That's her schedule. All right, so long as you believe that, you can accept that as true. You don't need us to show her cell phone records or something that she in fact leaves around 5:45 every day. Okay, so a single witness is sufficient to establish a fact so long as you believe that person. All right, credibility of witnesses. That is the cornerstone to our criminal justice system. Right, that is the cornerstone to our criminal justice system. It is up to you all to determine who you believe. You can choose to believe every single thing that every single person said. You can choose to believe just a little bit of what someone said, or nothing at all. Okay, it's completely up to you as to which witnesses you believe and what you believe. That is for you all's determination and no one else. All right, exhibits, again, those are the documents, the photographs, the physical evidence that's been tendered in this case. So here's the indictment in the case, and you will also have that back with you during your deliberations. I want to go through the charges here, and you'll hear this again from the instruction from the court, and you'll also get a copy. For malice murder, the state must prove that the defendant caused the death of another person unlawfully and with malice aforethought. Caused the death of another person unlawfully and with malice aforethought. Malice is simply the unlawful intent to kill. Okay, malice is the unlawful intent to kill. It is not necessarily ill will or hatred. Okay, it is simply the unlawful intent to kill. So how do you prove malice? How do you prove an unlawful intent to kill? There's two different ways you can prove malice. It used to be called express malice and implied malice, but you will hear that you can prove malice when the circumstances show that the defendant acted with a deliberate intention to unlawfully take the life of another. The deliberate intention to unlawfully take the life of another. Okay, again, this is difficult to look at, but this is the evidence of a deliberate intention to take someone's life. Okay, 81 stab wounds. That shows a deliberate intention to take someone's life. All right, now, you can also prove malice. Again, it used to be called implied malice, but you can also prove malice when there's no significant provocation and all of the circumstances show an abandoned and malignant heart. Okay, here there is no evidence of significant provocation, and this absolutely shows an abandoned and malignant heart. Leaving your girlfriend in the woods and setting her body on fire. Okay, so you have both types of malice in this case. Now, premeditation is not required. I know we watch TV and you hear it all the time of premeditated murder. Okay, that's not a thing in Georgia. There is no length of time required for malice to exist in the mind of the defendant. Okay, so long as the killing was done with malice, it's malice murder no matter how briefly that malicious intent existed. You will hear the court instruct you that malice can be formed in a moment and instantly a mortal wound be inflicted. Now you've heard here that it took a lot more effort than an instant. A lot more. But premeditation is not required. Likewise, proof of a particular motive is not an essential element to murder. Okay, we want to prove motive, but it's not an essential element to the crime of malice murder. Okay, someone could come in this room right here, shoot me dead in front of all of you, and we never know why, and that person doesn't get a pass just because we can't prove why. All right, so the main thing you want to focus on here is causing the death of another person unlawfully and with malice aforethought. That's it. Not the premeditation, not the motive, not the why, not the rest of that puzzle that gives context, but rather the essential elements of the crimes charged is causing the death of another unlawfully and with malice aforethought. Here's the language in the indictment. Count 1. Did unlawfully, with malice aforethought, cause the death of Beauty Couch, a human being, by repeatedly stabbing her. All right, next, felony murder. For felony murder, the state has to prove that the defendant caused the death of another person by committing a felony. Okay, it's really just two things there. Cause the death of another person by committing a felony. Felony murder occurs irrespective of malice, okay? You don't have to prove any sort of malice. You don't have to prove a deliberate intention to kill, and you don't have to prove that there was no significant provocation and all of the circumstances showed an abandoned and malignant heart. Okay? It's much like a math equation. Commission of a felony offense, death occurs, whether or not intended, that is felony murder. All right? Commission of a felony, death occurs, that's felony murder. So what is the underlying felony? It's aggravated assault. So what's aggravated assault? All right, aggravated assault, the state must prove that the defendant assaulted another person with an object which, when used offensively against a person, is likely to result in serious bodily injury. Okay? Assault and a weapon. So first let's talk about assault. All right, an assault occurs when a person attempts to cause a violent injury, such as stabbing them 81 times, or places the victim in a reasonable apprehension of immediately receiving a violent injury. Okay, either way, that is an assault. Now, for it to be an aggravated assault, right, it has to be with an object that, when used offensively against a person, is likely to result in serious bodily injury. All right, we do not have to prove exactly what that weapon was. You heard from the medical examiner's office that these were sharp force injuries, right? Sharp force injuries. Likely a knife, right, or a pocket knife, something along those lines, not likely to be scissors, some sort of sharp force object. Okay, we simply have to prove that it was an offensive weapon, which you can see with your own two eyes, based on the results, okay? And it likely caused serious bodily injury, and in fact did cause serious and deadly bodily injury in this case. All right, Beauty is dead. The lack of the murder weapon does not all of a sudden mean that this defendant's not guilty. The lack of the murder weapon does not cast doubt on the fact that an aggravated assault was committed against her and she bled out for minutes up to less than an hour and died. All right, so aggravated assault reads, did make an assault upon the person of Beauty couch with an object or instrument which, when used offensively against a person, is likely to result in serious bodily injury by repeatedly stabbing Beauty couch. Right, we have an aggravated assault, so going back to our math equation there, right? We have a felony that was committed. Beauty died as a result. That is felony murder. So count 2 reads, while in the commission of a felony, 2, aggravated assault, as set forth in count 3 of this indictment, did cause the death of Beauty couch, a human being, irrespective of malice. All right, arson in the second degree. For arson in the second degree, the defendant commits this offense as to a vehicle, which is what we're dealing with here. By means of fire, he knowingly damages any vehicle of another without her consent. Okay, it's very simple. By means of fire, damages a vehicle belonging to someone else without consent. There's the picture of the vehicle, right? Registered to Deanna. I know I asked her the question. I said, did you know your car was being set on fire? Did you want your car to be set on fire? Right? Of course not. There was no consent there. Her car was set on fire. It was damaged by that fire. All right, that's arson in the second degree. So, did knowingly damage by means of fire a Dodge Dart, a vehicle being the property of Deanna Thurman, located off Joe Jerkins Boulevard, Austell, Georgia, said damage be without the consent of said owner. Very straightforward. Concealing death of another. For concealing death of another, the state must prove that the defendant concealed the death of another person, which hindered the discovery of whether that person was unlawfully killed. Okay, so concealed the death, hindered the discovery. There's absolutely a concealing that went on here. You heard that it took a while to find her, that in fact law enforcement was parked so close to her body that they didn't even see her because of the efforts made to conceal her body underneath these branches. So count 5 reads, did unlawfully conceal the death of Beauty couch, which hindered the discovery of whether or not said person was unlawfully killed by placing her body in a wooded area covered in brush and setting her body on fire. Okay, again, straightforward as to the essential elements of the crimes charged. Tampering with evidence. For tampering, the defendant commits this offense when, with the intent to prevent the apprehension of or obstruct the prosecution of any person, he knowingly destroys or alters physical evidence. Okay, in this case, we have the vehicle that was in fact destroyed, so any physical evidence in it was completely charred. There was nothing we could have gotten out of that vehicle. Certainly no blood evidence at that point. All right, and her body as well. Any physical evidence that could have still been on her body. You saw her clothing burned, right? Some of it's still there, but a lot of it gone, no shoes. All right, so count 6, did knowingly destroy and alter physical evidence and forensic evidence by setting the body of Beauty Couch and a Dodge Dart on fire, said evidence involving the prosecution of the offense of murder with the intent to prevent the apprehension of and obstruct the prosecution of said accused. In other words, in his own case. So I asked you at the very beginning, I said, I'm a checklist kind of person and I want you all to keep a checklist as well. We've gone through these crimes relatively quickly, but as you can see, the essential elements of those crimes charged are absolutely proven beyond a reasonable doubt. Okay, we've absolutely overcome our burden as to the crimes themselves. And the crimes themselves are not really in dispute, right? We know that Beauty didn't do this to herself. We know she'd be incapable of doing this to herself, right? We know someone else did this. We all agree that the car was on fire. We all agree the body was on fire, right? So really what it boils down to is that second part of your checklist. Is this defendant responsible? Is this the person who committed these crimes? That's what it boils down to. All right, so I want to address the defense, some of the things spoken about in opening as well as during closing arguments. I'll then go through the state's case with you and the evidence that's been presented, and then I'll finish up with some final thoughts. So first and foremost, you heard Mr. Lumpkin go through a list of, I think it's highly unlikely he's guilty. I think it's less than likely he's guilty, all the way up to guilt is likely or guilt is highly likely, right? You are not going to hear any of this during the charge of the court. That is not in the law on reasonable doubt. Okay, that is not a part of the law. This is what the law says. A reasonable doubt is the doubt of a fair-minded, impartial juror honestly seeking the truth of the matter asserted. That is what you will be instructed on. All right, again, a reasonable doubt is a doubt for which a reason can be given arising from a consideration of the evidence, a lack of the evidence, or a conflict in the evidence. All right, now you took an oath to render a true verdict and to follow the court's instructions and the law that she's going to give you, okay? Do not let the defense guilt trip you into violating your oath or ignoring the law by making you think that someone is about to be wrongfully convicted. That is not a fair burden to place on you all. You all took an oath. The oath was to ascertain the truth. The oath was to follow the law. That's what we're asking you to do. Look at this evidence objectively. This is your decision. This is not about strong-arming people into one decision or another. Okay, this is your decision to render a true verdict. It is completely up to you all to make a determination as to whether the state has proven this case beyond a reasonable doubt. All right, remember one thing. This is not about getting a conviction. That is not what our criminal justice system is about. That is not what our criminal justice system is about. Our criminal justice system relies on jurors to do the right thing, to do the just thing, to follow the law, and uphold your oath, whatever that may be. It's not about getting a conviction. It's not about winning or losing. There is none of that in this system. Doing what's right, doing what's just, and following the law however you see fit. That is what we're asking. All right, in opening, the defense said that the investigation clearly showed that the only person they looked at was Eugene. But why? Ask yourself why. Okay, you heard Diana Jacques' 911 call requesting a welfare check on her son and Beauty. Right, because she had not heard from either of them. She was concerned. She was a concerned mother. And then you see a citation that was left on scene. Right, these are the reasons that while investigating, the detectives started looking into this defendant. Not just because he was the boyfriend. They didn't just pick him out of nowhere. There were facts and circumstances that led their investigation into Eugene Louis-Jacques. All right, the defense asked you in opening, but do they really even have evidence that Eugene was at the location where the body was found? And the answer is yes. All right, we're going to go through that in detail, and we're going to go through Special Agent Jay Burney's testimony as well as the testimony of Detective Smith. But yes, there is evidence that he was there. All right, the defense asked you in opening, why would he be calling to find her if he was there killing her? Right? Well, keep in mind, he was not calling her. Let that be clear. You have the phone numbers. I saw you all write them down, and you have the phone records printed out. He was not calling her, period. His last call to her was at 5:59 a.m., and he never calls her again. Ever. You have those records. Right? The defense also asked in opening, why would he be driving in the area trying to find her if he knew where she was? If he was truly trying to find her, why did he avoid Broad Street after leaving her residence in his own vehicle at 10:33 in the morning? Why would you not drive down Broad Street over and over and over and over again going, is she home yet? Is her car in the driveway yet? Why not go to Clayton University or Clayton State where she went to school? Why not go to the little dance class she worked at? He avoided Broad Street after he murdered her. And that was clear from his driving. Right? The defense also said, what they don't show us is Eugene was never where the body was found. Again, we will go through this testimony with you with the timing advance data that we have, but he absolutely goes in that area multiple times. All right, now, the defense has owned it. Yeah, he went to Louisiana, and that was a stupid decision, right? But he knew he was the most likely suspect. That's what the defense has said to you all. All right? Before the murder was known, keep in mind, this murder was not known when this defendant was already driving to Louisiana, leaving behind the hotel that he had rented through September 10th or whatever the date is, and he is already booking it out of the state, not just the county, but the state, before anyone knew she was murdered. A likely suspect of what? Remember, I asked Deanna Thurman, I'm like, when you learned that your car was on fire, what was your first thought? Did Beauty have any sort of medical disorders? And she's like, yes, she had seizures. It was well known to everyone around her she had seizures. So her thought is, well, my daughter must have had a seizure. But the defendant's thought was she must have been murdered by a stranger. That's so beyond illogical. That doesn't make any sense whatsoever. He was already fleeing the state before anyone knew she was murdered. Right? There is good reason that this defendant was the most likely and only suspect. Again, the welfare check, the citation that was left, their relationship, and then the domino effect. The pieces started falling into place as they started to look into him. That's called being a good detective. That's called following the evidence. And at no point in this investigation did they get somewhere that they go, we're on the wrong track? Right? They didn't pull his cell phone records and his cell tower data and go, oh, my goodness, he is in South Georgia at the time of all of this. Because had they obviously would have followed that evidence and realized he could be excluded and then start looking elsewhere. But there was good reason for them to start looking at this defendant while on scene, and all the evidence continued to add up. Now, lack of blood evidence. We told you at opening, right? We said there is no blood evidence. There's no DNA evidence, right? We weren't trying to trick you. We were being transparent, right? That's why we put all this stuff in. That's why we want you to see these reports that show that there was only really 3 swabs, one of which was insufficient to show whose DNA it was, right? And the other one shows that it's the defendant's own blood on his shoe. Right? We were transparent about all that. We're not going to skip evidence or pick and choose what you see to try to mask what's going on here. We're going to give you as much information as we can. It's our job and it's our duty. So that's why we presented all of this evidence. And we're very forthcoming with you from opening statements that there is no blood evidence. These were the efforts made. It did not get us anywhere. All right, again, lack of murder weapon. We were the ones, the state asked Dr. Ashraf, we're like, are these stab wounds consistent with scissors? No. What is it more consistent with? A sharp force object, likely something more like a knife or a pocket knife, right? We asked that to Dr. Ashraf because we want you all to know. There are photos of scissors that are in this defendant's car. Okay, we don't want you all seeing that in the corner of a picture or somewhere in a picture and thinking all of a sudden, oh, we have the murder weapon, the state missed it, now we know he's guilty. We don't want anything to be misleading to you all. That's why we're presenting everything, so that you can make a decision based on all of the facts in this case. All right, Special Agent Jay Burney. He obviously stood on his testimony. Why? Because the records don't lie. Okay, those pin drops from the minute he took the stand, right? I said, who is this phone subscribed to? Diana Jacques, right? Did I tell you that this was linked to this defendant? Yes. Did I tell you the victim's residence address? Yes. Right? Did I tell you which vehicle belonged to which person? Yes, right? In terms of those points of location, or points of interest rather, right? Those were provided by our office, and we were very upfront about that. Okay, that little icon, right, was slightly off in terms of latitude and longitude. In fact, y'all never even heard testimony of a specific latitude and longitude. Why? Because there isn't one. It's in the middle of the woods, right? It's in the middle of the woods in that power easement area. Okay, so he didn't change his testimony or want to change any statements because the records themselves don't lie. You heard why these records don't lie, because this is a gajillion-dollar industry that we all rely on, right, as phone companies. And so that timing advance data is never going to change regardless of where points of interest are. And we'll go through those for you all to look at. Now, in opening, the defense said there is reasonable doubt. They said it again during closing, that there's reasonable doubt. But I want you to really ask yourself, is there reason to doubt the essential elements of the crimes charged and this defendant having committed those crimes? Okay, the reasons, a lot of the reasons you're given are not essential elements of the crime charged, right? Or they're arbitrary and unreasonable, continuing to bring up this idea that 5 years from now, you're going to be watching a TV show with the real killer. There is no evidence of someone else involved, period. Reasonable doubt has to be based on fact and reason. So doing all these what ifs of what if you do the fingernail clipping and what if 5 years from now and what if this, that's not reasonable. In fact, that is unreasonable. That is unreasonable. That is trying to create doubt where doubt does not exist. Okay? Now, the defense also said a lot of this doesn't make sense. We agree. We agree wholeheartedly with that statement. Why? Because it is impossible to make sense of a boyfriend stabbing his girlfriend 81 times and going back the day after to set her body on fire. That's never going to make sense. That is never going to make sense. In fact, the defendant, in his journaling, doesn't even understand himself, right? Less than a month before this murder, he wrote he has rage. He has rage in his heart and malice in his mind, and he doesn't know why. So yeah, a lot of it doesn't make sense. Okay, but again, the why is not a reason to doubt the proof of these crimes having been committed and this defendant having committed them. All right, one question. I asked you this at the beginning, and I want you to continue to ask yourself during these deliberations, is there a reasonable explanation for all of the circumstantial evidence in this case? Is there a reasonable explanation for all of the circumstantial evidence in this case? All right, so let's talk about the state's case, starting with the timeline, all right? August 22nd of 2023 at 12:47 a.m., you have defendant calling Beauty. Again, you have these phone records for your deliberations. Now make sure you wrote down if you haven't already. It's always going to be in UTC time if it's from the phone company itself. So where it says 4:47, you have to subtract 4 to get it to Eastern Standard Time in Georgia. So 12:47 a.m., you have the defendant as the calling party, calling Beauty, right? And the duration was just under 22 minutes, right? So we know that they talked in those early morning hours. At 2:27 a.m., we then see that the defendant's vehicle hits a flock camera. Again, you'll have all those flock images for you, all right? And it's traveling westbound on Veterans Memorial. You heard testimony that sometimes it's called SR8, sometimes you'll see it as 78, or sometimes Veterans Memorial. It's all the same. So traveling westbound, which of course is in the direction of Beauty's house, and that's at 2:27 in the morning. All right, between 2:29 and 2:41 a.m., you have various areas in which his vehicle was captured on surveillance video or Fusus video. Now, all of this is in evidence. You can ask to see any of this again, okay, but you don't get a computer back there for your deliberations, so you can't do it yourself. If you want to see anything again, all you have to do is send a note and ask, okay? But this is the chronology of those spottings. You have 2:29. Then I know this says 2:50, but you remember you had to adjust it by 20 minutes. That was the one video that had the offset, so that's at 2:30, 2:33, 2:36, 2:40, again, because you had to do the offset, and then at 2:41. All right, so this is between 2:29 a.m. and 2:41 a.m. And remember, you actually heard Special Agent Bernie testify, no, I was not asked to map these things, but I did look at them. And in fact, there was this 16-minute period, he said, that the defendant's timing advance data puts him in the same area. So we know that this is his car, right? When you look at all these, and one thing I want you to remember too, is between these two times, you have him going down Broad Street. That's that AME church. And then when he turns around, he only has his fog lights on and he's turned off his main lights. All right, so if you look at the map here, what does this travel show you? Well, the very first point in time is at 2:27 when he's on the flock, which is over here on Veterans Memorial. Then you have one where he's turning on Austell Powder Springs here, and ultimately is going to drive down Broad Street right past her residence, right? Driving right past her residence at 2:29 in the morning, turns around at some point, because then he's seen coming out of Austell Powder Springs Street, and he ends up taking a left. I'm sorry, right. I can't do my right and left. He then comes back. He ends up circling back and going back down Broad Street. And that's with his headlights on. And then the last time he comes back down Broad Street is when he only has the fog lights on at that point. So he is circling her house, driving by it at least 3 times between 2:29 a.m. and 2:41 a.m.
All right, then we have a gap in time, right? Detective Smith testified he didn't have it specifically on camera, but it's somewhere in the area. But we see it again at 5:44. Now this time is not a coincidence, right? Because what happens at 5:45 every day, that's when Deanna leaves for work. So that time was not a coincidence. We happen to catch it on AME, the camera there, right, which is Broad Street. He's traveling in the direction of her residence. Here's another image here. This is the AME church on Broad Street, and he's traveling eastbound, which would go by her house right when Deanna is normally leaving for work. Probably checking, has she left yet? All right, again, 5:45, that's her normal time to leave her house. This is a picture of her house, right? It's right on Broad Street, so easy to see what cars are going to be in the driveway. Then at 5:45 a.m., we happen to catch his vehicle, and it's traveling now on Joe Jerkins, right? This behind here is Bethesda Baptist Church, which Detective Smith gave us a map of, right? The church backs up to Beauty's residence. I even asked Deanna about that, right? I said, what's like right behind your house? And she said, the church, right? That's Bethesda Church. You even have the distance there from the parking lot area where we ultimately see his car backed in at 6:01 a.m., right? And if he were to walk around the front path of the church and down through the cut or whatever between those two, or the backyard, that he would be right there at Beauty's house. And remember, again, while there wasn't a slide from Special Agent Bernie, he testified that yes, at 5:45, he's back in the area until about 6:15 or whatever the timing was. He said, and then there was a gap in data where there just was not timing advance. You remember he testified that sometimes if there's timing advance, there might be a tower identified, but if it doesn't tell you the distance, you really can't use it. So there's a gap in time there, but we know that he is in this area at this time based on the testimony you heard, in addition to the surveillance video that happened to catch this defendant. Now, again, phone records show that at 5:53 a.m. and 5:59 a.m., defendant calls Beauty again. All right, now this is a screenshot from his records, right, showing he is calling her. And you see that the actual elapsed time, so the connected time is 3 seconds and then 2 seconds. So there's no indication those were actually answered. That could just be voicemail picking up as opposed to actually speaking. But we know that the phone rang on both occasions and that the elapsed time was only 3 seconds and then 2 seconds. You can also see this on Beauty's records. We put Beauty's records in. And if you look at Beauty's records, every single phone call on August 22nd was an incoming call. And you will go through the column. It makes it very easy since there's no outgoing calls. You can go through the column and see that 5:59 is the last time he ever calls her. Compare the records. Put them on top of one another. There is never another communication between Beauty and Eugene. At no point does he call her, bombard her, call her on repeat. None of that. Even though there's multiple calls prior to. 5:59 is the last time he ever reaches out to his girlfriend, who he moved to Georgia for. At 6:30 in the morning, Beauty posts on Instagram for the last time, right? You heard her friend testify, Antonasia. She said, this was the last time I ever saw anything of her, was posting at 6:30 in the morning, right? And you'll have that with you. At 7:35 in the morning, you see the defendant's vehicle again. Now, it is on this little side type street that dumps into Joe Jerkins. And I asked Detective Smith, I'm like, what is that? He said he suspects that's what connects to the Bethesda Baptist parking lot, right? It's not a separate road. It's not Vine Street, because if you remember Vine Street, it's kind of hidden by the adjusted time, or the timestamp there, but Vine Street's up here. So this is a private drive. So at 7:35, you have his vehicle coming out from Bethesda Church. He drives eastbound down Joe Jerkins, turns left onto Austell Powder Springs, and then ultimately ends up taking a right onto Veterans Memorial Highway, right? And that timestamp is at 7:36 in the morning. At 7:50, so some 14 minutes later, is when you see the defendant's vehicle traveling westbound on Veterans Memorial, hitting that same flock camera he had hit previously. Now, yes, that indicates he did some sort of big circle or whatever because he was traveling westbound on Veterans Memorial, so he would have had to do some sort of loop, but he had 14 minutes to do that. All right, then at 7:52 in the morning, the defendant continues westbound on Veterans Memorial. We see the car there, and ultimately the car turns right onto Austell Powder Spring Street, and then luckily we have the Fuses camera that shows he actually does pull onto Broad Street. Remember, this one is Broad Street here. So at 7:52 in the morning, the defendant is turning right onto Broad Street towards Beauty's residence. All right, if you look at all of these times in order here, you have 7:35, 7:36, right, then it goes on to 7:52 through 7:52 and 52 seconds there. All right, so again, to get a visual there, he had been parked at Bethesda, right? He's seen pulling out onto Joe Jerkins. We know that he then goes left on Austell Powder Springs and ultimately travels westbound on Veterans Memorial. At some point in the 14 minutes, he does a big circle of some sort to get back over here because he then hits Flock over here, comes back down Veterans Memorial, drives up Austell Powder Springs, and then turns onto Beauty Street right here. Broad Street at 7:52 in the morning, okay? So that's the sequence of events, and again, you can always ask to see these videos again. All right, sorry about that, I left off 6. So 6 is where he's ultimately turning onto Broad Street, which is going to go back by Beauty's residence at 7:52, okay? And keep in mind, I asked Deanna, I said, well, what time would she normally leave for school, right? Because she goes to school in Clayton County, what time would she normally leave? And it's around 8, right, to give wiggle room to be able to get to school by 9. Right, so his timing of pulling onto her street at 7:52 aligns with when she would normally leave. Isn't that interesting that she's driving by at 5:44 in the morning when Deanna leaves, and then he's going back by right about the time that Beauty would normally leave for school. All right, now, it is presumed from 7:52 in the morning to 10:33 in the morning that the defendant is backed into Beauty's driveway. All right, why do I say that? Because we know that there is a white vehicle, right, that you can see right here that's backed into Beauty's driveway there. Remember, this is the neighbor. They have the timestamp here from August 22nd. That's at 9:57 in the morning, right? So we don't unfortunately get to choose when the ring films and doesn't film. You heard there's a train track, that there wasn't footage every time a car drove by and so forth, right? We just happened to get lucky with the resident walking out at 9:57 in the morning, which is where we capture the front end of a white sedan. Right, that's zooming in there to show you that front end of the white sedan that's parked in Beauty's driveway. And remember, it's her and her mom, right? She's supposed to be at school in her red car. You heard about Deanna's car, but we know there's this white vehicle backed into her driveway. Now, we also know that the defendant has backed into her driveway previously due to other ring footage. So the date on this is from August 19th of 2023 at 7:44 in the evening, where you see his vehicle is backed into the driveway. Okay, this is not on August 22nd. It's just showing we know that he does back into that driveway. He had done it a couple days prior, right? So we saw this footage with you all. So we know at 7:52 he's turning onto her street, and then his car stops moving, right? We don't see it on Flock or anything again until it's coming off of Broad Street at 10:33 in the morning. So that's why we say it's presumed between 7:52 in the morning until 10:33 in the morning that he's left his vehicle backed in her driveway while he's murdering her and then taking her car to Fulton Industrial. So the next time we see Beauty's vehicle move, or I really should say the first time we see her vehicle move on August 22nd is at 8:10 in the morning. All right, we see through the bushes, right? RB was able to see through the bushes. We had to zoom in and go frame by frame, but you can see the red coloring of her car pass. That's right around 8:10 in the morning. And then the next clip we have is her driving eastbound on Broad. Okay, so that's where we know that her vehicle is now moving. So just to give you a visual of that, right, we know this is her residence. The camera is here at Austell Gas and kind of goes through the bushes, which is where you get that glimpse of her red car. So the vehicle would have circled around the block on Vine Street and then continued in an eastward direction on Joe Jerkins. I'm sorry, yes, no, Joe Jerkins is active. All right, so then at 8:33 a.m., so you have about 23 minutes, right, after he's been traveling in the direction of that power easement, in the direction of where Beauty was ultimately discovered, we have her vehicle coming back. So now it's traveling, can't do my east and west, I guess the other one was west, this one's east. Going eastbound on Joe Jerkins, right, which is ultimately spitting out here at Austell Powder Springs, where he then takes a right onto Austell Powder Springs, and that's at 8:33 in the morning. Right, so there's been this 23-minute gap where he was driving in the direction of that power easement where she ultimately was discovered, but then we see the vehicle again. Now, from 8:45 in the morning, ultimately to 10:23 in the morning, we see that Beauty's car is traveling. All right, there are numerous flock hits. You have those flock hits, all right, and they're designated here as well, but we walked through them with Special Agent Jay Burney, where her car goes down in this area, it circles back around, right? Because here's that same number 5 flock hit, and ultimately ends up hitting number here at number 8. You heard from Detective Smith that CES, I can't remember what it stands for right now, but he said that CES company where he got the 2 still shots of Beauty's car, he said that was off of Frederick. And as you'll see in the flock hits, which you'll have to consider, that flock hit is on Frederick, or I think that's how you pronounce it. Anyways, right here. So it aligns perfectly with the timing of the flock hit. And in fact, if you remember, that's how Detective Smith even knew to go to that area to look for surveillance video, because her vehicle had hit flock in that area. So he wanted to see if he could get any footage of it, and in fact was able to get those 2 screenshots for you. All right, and going back just a moment here, as you heard the testimony from Special Agent Burney, he looked at the totality of all of the timing advance records that were available to him for this defendant's phone, right? And he said that all of it was consistent with the travel in Beauty's car. He, of course, depicted the ones that were most relevant and easy to see, and we went step by step. I know it was brutal, and I know it's hard when it's Friday of Memorial Day, but really lining up that all of the flock hits aligned with his timing advance, down to where it's seconds apart from getting to one location to the next location, completely consistent with vehicle travel, right? And it matched up with Beauty's vehicle and Beauty's vehicle driving. So we know that this defendant is in her car. We know that. All right, then at 10:22 in the morning, we see the Dodge Dart, unfortunately past a police officer, right? That would be Eugene in the car. We know he's in the car. We know his phone's in that car. And ultimately, it does not turn on Broad Street, right? It continues on what street? Joe Jerkins. What's the only entry and exit point to get to where ultimately her car and her body was found? Joe Jerkins. There is not another point, right? You can't get there off of Austell Powder Springs unless you drive off the bridge. All right, so we know it's no coincidence that at this point in time, at 10:23 in the morning, he is turning on Joe Jerkins in her vehicle in the direction of where ultimately her body and her car are dumped. You then see at 10:23 a.m. another clip from the Austell gas that's by the church, right? And once again, that vehicle is traveling westbound on Joe Jerkins in the direction of where that power easement is. To look at it here, this is where that camera is. The red Dodge Dart is traveling westbound here, which ultimately gets you to the vehicle access point for the power line. All right, we also know based on his cell tower data that is consistent with this movement. That's how we know that his phone is inside that car. All right, we can zoom in here to where his timing advances at 10:23 a.m., so the exact time that we actually have the Dodge Dart on surveillance video, and you see that the defendant's phone is within 0.1 miles of the tower. Right, that 0.1 miles, remember the width of these timing advance circles or arcs or whatever is going to be 78 meters. So you can't really distinguish, well, is someone on Broad Street or someone on Joe Jerkins, because those are only 100 and some feet apart from one another. So no matter what, it would be in the same width of the timing advance, right? But we know when you look at it combined, we have her vehicle on Joe Jerkins, and we have his phone hitting in that space that would encompass both her residence and Joe Jerkins. I mean, mind you, where this vehicle is right here, the other side is going to be her residence, right? So it's going to show the same thing. Then at 10:33, so 10 minutes later, all of a sudden, you have the defendant coming out in his vehicle, right? Never do you see these vehicles moving at the exact time as one another or hitting flock or anything else. So you have him pulling out from Broad Street because, again, he was parked at her residence, backed in. He's pulling out, and then he ultimately will take a turn onto Joe Jerkins traveling eastbound. He is never, ever, ever seen again on Broad Street, period. That's it. Right after he's done murdering her. Doesn't want to go back on Broad Street. All right, then at 10:40 to 10:45, we see that he has additional travel. He's traveling northbound based on his time in advance. If you zoom in here, this is the intersection that he was at 10:33 in the morning, and you can turn onto Joe Jerkins and ultimately get onto, blanket on the name of the street, but it will connect you to Austell Powder Springs. And you remember, or Austell Road, and you remember Special Agent Bernie testifying that based on the prior hits here between 1 and 2, that it seemed that he was traveling northbound on Austell. And so this is completely consistent with the direction of travel. We last saw his vehicle at 10:33 in the morning, ultimately when his cell tower data picks back up with timing advance at 10:40 in the morning. All right, at 1:59 p.m., the defendant then returns to Joe Jerkins, right? And this is that Austell Mill and Sweetwater Mill cameras that we see. So we actually have his vehicle captured there, which is on Joe Jerkins. And that's at 1:59 p.m. So this is the first time he's returned to the area after having killed Beauty, right? Then at 6:46 in the morning, or in the afternoon rather, evening, we see his vehicle again go to Joe Jerkins. This is captured on those mill cameras there, right? And in this case, he pulls up here. He ultimately gets stopped by the train that's passing, so he turns around, right? He's like, I'm not going to sit there and wait on the train. I'm going to turn around. This is the second time that he's back in the area where his vehicle is captured on these surveillance videos. Then we get to August 23rd, right? So we're now in the next day, in the very early morning hours. At 1 a.m., the defendant returns to this area for a third time, right? A third time. This time we see him coming on Austell Powder Springs, right? You can even see that body side molding. You can see that it has the sunroof there. He then turns on Joe Jerkins traveling westbound there. All right, again, you see that sunroof, body side molding, dark tinted windows. This is the third time he's in that area at 1 o'clock in the morning, no less. All right, at 1:02, he's captured on that Austell Mill camera and does that kind of, he stops for a second, no one gets out or anything. He stops, pauses, does some weird three-point turn, and then goes back. What does that mean? Well, he's just traveled down Joe Jerkins, so he's gone by the access point once. He then gets here, turns around, and goes back, so that's going to be his second time driving by there at 1 o'clock in the morning. And then he comes back, so that's going to be a third time that he passes that same easement access at 1 o'clock in the morning on August 23rd. All right? Now, if you look at the same data from Special Agent Bernie during this time frame, it matches up perfectly, and I'll show you that. So if you zoom in here, right, this is the area we're looking between, if you remember, these three bigger arcs here are associated with the tower that's aligned at 2 degrees. Right, and it goes from biggest to smallest, 0.78 miles, 0.73 miles, 0.68 miles. So 1, 2, 3, and the timing of those is 1:01, 1:03, 1:04. Okay, so here at 1 o'clock and 41 seconds, that's when we see him turning on to Joe Jerkins Boulevard from Austell Powder Springs. All right, from there he would have picked up, and this is the turn here, right? This is the turn that would put you onto Joe Jerkins. So he's going to be right about at that intersection of the timing advance data at 1:01:26, right? That's only 40 seconds or so later, so it matches up with his vehicle traveling there. We then know that he's traveling on Joe Jerkins. I know it's hard to see, it's faint. He's traveling this direction, and this little pond here is part of the plant. And you can see that from all the records that have been put in for you. At 1:02 a.m., he's captured on that mill video. On 1:02, he then does that weird turn to go back in the direction of Joe Jerkins, right? So he comes here, he does a turnaround, drives back down Joe Jerkins, right? Not surprisingly, at 1:03 and 57 seconds, after he's done that turn and everything at Austell Mill, is when he's at this middle arc there, right? That encompasses part of Joe Jerkins, right? If you were to just stay straight on Joe Jerkins. Then he gets down to this, the third arc there at 1:04 and 42 seconds, which again captures a good part of Joe Jerkins. And not surprisingly, some minute and 20 seconds later, he's back captured on that mill. Okay, so that's how we know that he's in his car. That's how we know that all of these pictures that Detective Smith was able to get and all this video footage is in fact this defendant traveling in his car. Okay, these records do not lie. They don't change no matter what. These are phone records, and you've heard how reliable they are. All right, skipping ahead to 9:30 in the morning, the defendant then drives down Joe Jerkins. This is now a fourth time. All right, fourth time that he's driving down Joe Jerkins. He's captured on the Austell gas. And again, this travel is obviously in the direction of where Beauty's body is dumped and where the car is. You then see that at 9:44, 14 minutes later, right, we see the defendant's vehicle now at that Austell Mill. Now, it does not take 14 minutes to get from point A to point B. You've seen that in prior footage, right? And Detective Smith testified to it. It doesn't take that long to get from point A to point B. So he's somewhere for 14 minutes setting fires, right? Plenty of time to set the fires, and then we pick him back up at that time. Now, how precisely he set the fires, why it is that the car burned so long before anyone noticed, or why the car didn't burn faster, or whatever, right? That doesn't change the fact we know those cars were set on fire, and we know this defendant was in that area. All right, 9:26 to 9:46, if you look at that same time frame provided by Special Agent Barney, right, it all aligns there. Again, so this point right here at 9:30, we have the defendant hitting this area. Now, if you recall, that's at 9:27 and 49 seconds when you're looking at the sector that's pointed at 122 degrees and it's 0.82 miles from the tower, right? That's this big arc on the outside. So that's where his vehicle or his phone is hitting at 9:27 in the morning, and then it's just to the west of that by 9:30 when he's now turned down Joe Jerkins, and we capture him again at that Austell gas location. Then at 9:44, we have him right here at the corner by that mill, right? And in between then, from 9:31 all the way to 9:40 there, when we're on that number 2, or the tower facing the 2 degrees, right? You have all these hits that are around 7.7 miles or so from the, what's it called? The tower. So that's in these shaded lines here, right, which encompasses that area between Austell Powder Springs and Joe Jerkins Boulevard there, okay? So that's right in that area during the time that he's there setting those fires, all right? 10:15 to 10:30, you then have the defendant going to his extended stay, right? There's a lot of other areas he goes. They're really not important. We just wanted to make sure you all knew he did not go back to that area, or at least we have no data to show that he went back to that area. But what is important is that at 10:15 to 10:30, his timing in advance is exceptionally consistent with him being at the Jacques residence or at his extended stay where he was staying, right? So we know that during that time period, and thereafter he ends up going to the racetrack. Now we know that it's after 10:54 a.m., right? Because at 10:54 a.m., he's hitting number 8. He's the farthest from the tower, so it's over here, very consistent with his flock hit at 10:54 a.m. And then as you heard Special Agent Barney testify, he then is in the area of that number 9 hit. He didn't have that exact location, but he said he did look up the racetrack, and it was very much consistent with this general area there. From 10:56 to 11:04, the defendant stops at that racetrack. He is there for 7 minutes. That is a long time to be at a gas station, shoving things in the trash can and never going inside to get a drink, to get food, to get snacks, to pump gas. So he's there for 7 minutes. He makes multiple trips. Apparently, this whole trash can was full, so he had to go to the other trash can that's by the gas pumps. And there we see him get out of the car, shove more things in the trash cans there. Random gas station, didn't pick one close to his house, didn't pick one close to the victim's house. All right, then he pulls out, and that's at 11:04 a.m. Now, how do we really know that's him? Because you can see the vehicle. They both say courtesy there. In fact, there's a little dent in the back of his car that you can see here. This is the photo from his vehicle being processed. You see the same dent there. You then can see the tag number. You see the body side molding. You see the sunroof. You see the dark tinted windows. You can see that those tags line up. It's hard to see every single number there, but when you look at all of this, you can certainly make enough out to know that that's definitely his car, in addition to the fact that his phone records put him there. Then at 12:16 p.m., Austell PD is dispatched to a brush fire. Of course, that's off Joe Jerkins Boulevard. Not a person on fire, not a car on fire, right? Someone just saw smoke and thought it was a brush fire. That was what they were initially dispatched to. Granted, this view that you see is from Austell Powder Springs. That is not from Joe Jerkins, but you can tell there's not much to see. You don't drive by and go, oh wow, there's a dead body in a car on the side of the road, okay? 10:33 is when Austell PD arrives on scene. And keep in mind, at that point, they only know that it's just a car on fire. They actually have to go back, make contact with Deanna and so forth before they ever even know that there's in fact a human. All right, at 2:39 p.m. to 2:48 p.m., the defendant then returns to the area for the fifth and final time. All right, the fifth and final time. This is the fifth time he has gone there since murdering her. All right, this is no coincidence. We can see at 2:45 p.m., his car is captured by Austell Gas. All right, he's driving in the direction that would go to the body dump location, to that only entry-exit point off of Joe Jerkins, right? And then he ultimately ends up dumping out where Joe Jerkins takes that turn by the mills. All right, so we know that he's driven past, and at this point, law enforcement's there. We know law enforcement's there. What we also know is the medical examiner is not there, right? That's the timeline we established with the officers, is that there's no medical examiner's truck at that point in time. They had to wait for the medical examiner to arrive. So there's no indication there's a body. And even then, you're not even seeing a car anymore, right? They took the car, they towed the car. So there is nothing there but police presence, no indication of a human body, but all of a sudden he's like, I gotta get out of Dodge because I'm gonna be the prime suspect in a murder? All right, so immediately thereafter, he flees to Louisiana. And I mean immediately, okay? This is important. 2:45 is when we see his vehicle that's right there at Austell Mill. By 3:13 p.m., he's already south of Atlanta. So don't let that timing confuse you at all. This is after he's been traveling south for a period of time. So he immediately flees to Louisiana. What does that mean? That means his car's already packed, and we know his phone is in it because the phone gives us the data, all right? The only reason this defendant knew what police were investigating and what they were responding to is because he murdered her and he set her on fire. There's no other explanation for it. It's that simple. It's as simple as the baby powder. That is the only reason he knew he needed to get out of Dodge immediately. That is all you could see. But he is the only person on this planet that knew Beauty was down there and she had been stabbed 81 times because he did it. All right, there's no other explanation for him immediately fleeing the state but for his guilt. But for him being the only person who knew where her body was and knew what he did to her. All right, we told you there were three important pieces of evidence: the defendant's location, the property, and his behavior. All right, defendant's in the area of Beauty's house the very last morning she's known to be alive. Right, we have him parked there at 6:01 and she's posting on social media at 6:30. That is not a coincidence that he is right there in her backyard at the last time we have a sign of life. All right, he then travels in Beauty's car. We know that from the timing advance data to Fulton Industrial. Why? We don't know. Not an essential element of the crime charged, right? And then drives back to her residence in her vehicle. Going back, so that's for a period of, I think, 8:45 to 10:23, right? So what he's doing in her car, we don't know. All right, but we know that it's completely consistent with all of the flock hits. His phone records are completely consistent with all of those flock hits of Beauty's car when we know Beauty has 0 signs of life. All right, he then returns to the area of her residence in the body dump location 5 times. I told you 4 during the opening, I made a mistake. It's 5. 1:59 p.m., 6:46 p.m., between 1 o'clock and 1:06. That should have said a.m., my apologies. And there's 3 passes down Joe Jerkins at that point in time, from 9:30 to 9:44, and then at 2:45. 5 times he goes back to this area, but he doesn't drive on her street because he's not looking for her alive. He's looking to see if anyone's found her body. All right, the defendant then flees to Louisiana after police find Beauty's vehicle and body. Again, this is before 3:13. This is immediately after he drives by that he heads south, which means his car was packed, he had his phone, he had cleaned out his extended stay. All right, he was ready to go immediately once he found police on scene. Now, why he waited, again, I don't know, right? But that's not an essential element of the crime charged. All right, the defendant's parking citation, now looking at the property that leads us to him, his parking citation was left near Beauty's body. I understand the defense saying, well, I mean, how stupid is that? Surely he didn't leave it because it would be too stupid. Well, he did. Maybe he didn't notice it. Maybe it was an accident. Maybe it fell out when he's trying to drag full trees basically on top of Beauty, right? But somehow it got left. Not planted, but left. All right, and that citation goes back to his vehicle that we know belongs to him, right? That's the white Nissan Altima. And we know that that particular tag expired in April of 2023, which is why it's a different tag number at that point in time. All right, then once we find him in his vehicle, we know it's now the JTYR51 tag, right? And we find him inside that vehicle in Louisiana. We then see that there's a burnt piece of paper in his car. It's not a coincidence. Is it stupid? Sure. But it's not a coincidence. Again, we don't have to prove why he put this in his car, why he kept it, why he didn't notice it or throw it away, right? Those are not essential elements of the crime charged. But this is not a coincidence. All right, there's blood in defendant's room and shower. These are the 2 markers. All right, that there's blood as well as the shoe. Now understand, this is an extended stay. All right, this blood could be anybody's. There's insufficient DNA to say whose it is, when it's from, what it's about. Okay, so we are not asking you to convict based on this, okay? Not at all. I want that to be abundantly clear. But then he also had blood on his shoes. It's his own blood, okay? It's his own blood. And we agree, there are no signs of injuries or marks on his body that anyone observed, right? But he has blood. Now, I don't know, could have been a bloody nose. Who knows, right? And it could be unrelated to this. All right, but there's blood on his shoes that are in his car that was packed already, ready to go when he drove back for the 5th time. All right, then we have paperwork that was also found in his vehicle showing that he starts using this new name of Michael Waters right after Beauty's murder, right? He applies to work at a golf club, right? Using the name Michael Waters, he'll take any position, and then he gets a new phone. He gets a new phone. Now we know he had his phone with him, the phone that he had on him when he committed this murder and arson and concealing and everything else, right? Because we see it travel down to Louisiana. No idea what happened to it, but he did get a new phone, now in the name of Michael Waters. Again, not a coincidence. All right? Now, with respect to his behaviors, which we told you was also important, he calls Beauty, right? Again, this is the girlfriend he moved to Georgia for. All right, he calls her at 5:59 a.m. for the very last time ever. Never tries to call her again, period. That was it. All right, he refuses to answer any of the 24 phone calls from Deanna. 24 calls. Now, this is just a little chunk of those calls, all right? You have the records that show all 24 of them. You can see it because every time you'll see the 6978 number as the calling party, calling the defendant, right, which was the 6329, and you basically bracket these together. So you see where Deanna calls him, it's then forwarded to the voicemail as the detective explained to you, right? So it's missed call after missed call after missed call. But isn't it funny that he misses the call and it goes to voicemail when Deanna calls him? In fact, it doesn't even really ring there. It's 3 seconds and goes straight to voicemail, like being blocked, right? That happens at, I can't do math, whatever 21 is minus 4, right? 8 minutes later, he answers, or in fact calls his own mother. So he has his phone. He calls her 8 minutes later and they talk for 1 minute and 31 seconds. That is his number because he is the calling party, and he calls his mother, the 913 number, 8 minutes after all these missed calls from Deanna, intentionally ignoring her calls, but then talks to his mom for 1 minute and 31 seconds. All right, but then he ends up ghosting his own mother, right? He doesn't talk to her, which ultimately leads her to be concerned enough for both Beauty and her child to call in the welfare check at 6:09 on August 23rd. All right, the extended stay, there's basically nothing left inside, right? You'll have those photos to go through, but it looks like someone cleaned it out. I mean, the bed's not made or anything. That's no big deal, kind of normal, right? But the only thing there is like this perfect set of flowers and a note about can't wait to, you know, start our lives together or whatever from Pookie. But everything else is in his car. I mean, he has packed his car because he's not coming back. He's starting his new life as Mikhail Waters. All right, again, he was supposed to stay there through September 10th, but he up and left on August 23rd after he saw that police had found Beauty. And again, why is he leaving? I mean, welcome, I love you, I look forward to creating new memories in this home and our future house, Pookie. So then why are you up and leaving with all of your stuff packed in your car? Doesn't make sense. And then of course, again, this makes no sense to the point that an officer who wasn't even involved in this case is like, that doesn't make sense.
Why'd you lie about your name? There's a reason. Tell me the truth.
Tried to avoid getting caught.
Getting caught for what?
I was trying to get out of that situation, making that wrong turn.
What are you trying to avoid getting caught for?
He knows he's got a warrant out of Georgia already.
No, he doesn't.
I didn't know I had a warrant. I was trying to avoid getting in trouble for making that illegal turn. He said I was making the legal turn as I was turning to the lane.
Why would you give a fake name to avoid getting out of a ticket?
I thought y'all maybe let me know.
Nah, that don't make no sense, man.
Thought y'all would let me go if I give a fake name. I mean, it makes no sense. But the first thing out of his mouth, the first reason he gives is because he was trying to avoid getting caught. He knew what he had done. He knew what he had done, and he knew he was on the run. There is no innocent explanation for all of these behaviors. There's just not. If you look at all this evidence, you cannot make sense of it aside from this defendant's guilt. Okay, the defense asked you at one point in opening, is there anything you can put your finger on, a reason you can identify that casts doubt as to the defendant having committed these crimes? There is nothing. There is nothing without ignoring evidence. You would have to ignore evidence to come up with any reason. Okay, again, I will ask it again. Is there a reasonable explanation for all of the circumstantial evidence in this case? You can't fabricate this amount of circumstantial evidence. You just can't. All right, is there a reasonable explanation for the defendant driving in the area of Beauty's house from 2:27 a.m. to 7:50 a.m.? Is there a reasonable explanation for the defendant calling Beauty, his girlfriend, who he loved, at 5:55 in the morning and never calling her again, ever, period? Is there a reasonable explanation for his phone traveling with Beauty's car to the area of Fulton Industrial back between 8:10 a.m. and 10:23 a.m.? Is there a reasonable explanation that the defendant leaves Beauty's home at 10:33 in the morning and is never again captured on Broad Street, despite all those times we captured him on Broad Street before that? Is there a reasonable explanation for the defendant driving back in the area of where he dumped her body and car 5 times during the 27 hours that followed? 5 times. Is there a reasonable explanation for ignoring 24 of his girlfriend's mother's phone calls? Is there a reasonable explanation for fleeing to Louisiana at a time when no one else knew she was murdered? Is there a reasonable explanation for getting a new phone? Is there a reasonable explanation for essentially trying to start a new life with an alias to avoid getting caught? Because avoiding getting caught on a traffic infraction based on a fake name is not a reasonable explanation. In fact, that's an illogical explanation. Is it just a coincidence that he has this burnt paper in his car? Is it just a coincidence that he has these shoes? Is it just a coincidence that his girlfriend was stabbed 81 times and set on fire at the same time that he then changes his name and flees the state and starts a new life? These aren't coincidences. These are not coincidences. If you've ever heard the phrase, it's too much of a coincidence to be a coincidence, that's what we have here. All right, this evidence has proved this defendant's guilt and no one else's. All right, this is the puzzle we want. I understand that. This is the puzzle that we want. This is the puzzle that we want to bring to you, that we want to put together with you. All right, unfortunately, this is the puzzle we got. All that background that makes a perfect picture that you can make sense of, that has the trees and the mountain and the lake and all of that that we want, we don't have. What's missing? The why. What sparked the rage? When did he first stab her? Was it an ambush when she's getting into her car? Right? Where did he first stab her? What stab wound of the 81 was the first one? Did she say anything? Did she suffer? Was her body in the car for those 2 hours that he was driving around? Or had he already dumped her? How exactly did he set those fires? Right? We want that information because that will give us the perfect puzzle. And there's more missing pieces. We recognize that and we told you that in opening, right? There's no video. There's no video. There are no fingerprints or fingernail clippings, right? There's no DNA evidence proving the murder. There's no murder weapon. Now again, we know a murder weapon was used because we know she was murdered no matter what way you look at it. All right, none of Beauty's blood was found on his person or in his property, right? We don't have proof that he purchased gas. We have proof that he made a ton of cash transactions and actually had cash at the time he was arrested, right? We don't have that receipt. We don't have Beauty's cell phone or his cell phone, right? We don't have direct evidence of his identity, meaning an eyewitness who said, I saw it and this is how it happened. But those missing pieces does not change what you do have. It doesn't change what you do have. You could find missing pieces to anything. Even something entirely captured on video, you could say, well, where's the gun? I see on the video everything that happened, but where's the gun? That's a missing piece. Does that change what you see? Does that change what the other evidence proves? No. And keep in mind, who's responsible for all these missing pieces? That man. That man is responsible for the missing pieces. He lay in wait to avoid witnesses by sitting outside her house at the wee hours of the morning, driving past to make sure that Deanna wasn't going to be home, making sure that there was no eyewitness. Right? He burned the car so that we wouldn't have his fingerprints in the car. He burned the car and made multiple trips to trash cans, shoving things in trash cans at the racetrack, right? So there would be no DNA evidence. There would be no murder weapon, right? He washed away, threw away, burned blood evidence. there's nothing left in that car. I mean, whatever was in that car and whatever evidence was in that car, it's gone. He's guilty of tampering with evidence. He's guilty of arson. All right, of course, there's no gasoline, proof of gasoline purchase or that receipt, right? He's throwing everything away. He got a new phone under a new name. He got rid of any direct evidence that would prove him to be a murderer and then started a new life. What's the direct evidence that he got rid of? Well, for starters, beauty. Because if she had survived, that would have been your direct evidence. And then using fire to get rid of everything else. Fire and trash cans. I want to leave you with some final thoughts. I think all too often in a criminal case, all we do is talk about the defendant. Talk about what the defendant did, what was in his property, what was found, what his records say. And everything is about his actions. And all of those actions and all of that evidence tells you a story where you put those pieces together in order to determine what happened. But there is one more witness that we wish we could have called. Because had we had this witness, there would not be any questions left. We would know exactly what happened. Ladies and gentlemen, that's Beauty Couch. This is the only witness that could have told you everything. But we don't have the luxury of allowing her to tell you what happened. We instead have to rely on the evidence that's left behind. You heard that she was Deanna's only daughter. Deanna adopted her as a baby. Parents aren't meant to lose their children. And she had no idea that after saying prayers in the morning and leaving at 5:45 on August 22nd to go take care of other people's children, that it would be the last time she saw her own child. She had no idea that while she's with joyous little pre-K children, that this man right here was viciously stabbing her daughter to death in the woods. And leaving her there to die and suffer slowly and alone. But he couldn't stop there. He wanted to go back again and again and again, eventually setting everything on fire. So no, we can't answer why. We can't answer why this apparently lovely boyfriend of hers would stab her 81 times and then light her body on fire. But the evidence points to him and only him. And because of his actions, and because of his choices, this is all that was left. Beauty's burned up skate with her name engraved on the side. Ladies and gentlemen, this case is about to be in your hands. It's not about getting a conviction. It's about doing what is right. Doing what is just. Returning a true verdict. All of this evidence that was presented, all of the exhibits you're going to get back
when you're deliberating, tell one truth and one truth only. And that is that this man is guilty of every single count in this indictment.